The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
All right, please be seated. Let's get started. Our first case is 24-1486 Porter versus Trans-States Holding. Mr. Mitchell, you may proceed.
May now draw near and they will be heard.
Good morning. If it please the panel, Attorney Robert Mitchell on behalf of Appellant Ken Porter. A court should never dismiss a USERRA claim after an employer admits that the employee's service membership was a motivating factor in the employee's adverse employment action. USERRA is a strict remedial statute that must be liberally construed to protect our service members, the individuals who drop their personal affairs to take up our country's call to duty and in defense of our nation. USERRA is a very simple statute that has a few simple requirements to present an initial showing of discrimination. One is that the individual is a service member. Two is that they work for the employer. Three is that they suffered an adverse employment action. And four, that their service membership was a motivating factor. In this case, what we see is that Captain Porter worked for Trans-States Airlines, who all referred to as TSA, for 14 years. The last 9 years of his tenure with the airline, he begged the airline for a promotion to the position of line check airman. In 2013, he was finally placed on the list to be promoted. There were only 2 pilots on that list. Out of the hundreds of pilots that worked for Trans-States Airlines, there was Captain Ken Porter and one other individual whose name is redacted from the email. Ken Porter was not promoted. We know that for certain. When he asked the decision maker, who was Stuart Scott, why he was not promoted, he was not getting a straight answer, so he asked Randy Zender. Randy Zender was on the email chain that was sent to a group of decision makers to determine who was appropriate to be promoted. Randy Zender responded to him, and this is a fact that was taken as fact by the court, an undisputed fact. He stated, well, you also do a lot of military service.
Was Mr. Zender a decision maker?
If the court will turn to page 365 of the record, there was an email from the actual decision maker, who was Stuart Scott. He sent an email to a group of individuals asking them for their input. So he did not make the actual ultimate decision, but he was a part of the decision-making process. And he responded to that email. The email states, I'm considering the following pilots for the position of line check airman. This was Mr. Porter's chance to be promoted to line check airman. There are only 2 individuals' names on that list.
Well, did you depose Mr. Scott if he was the decision maker and examine the motivations behind the failure to promote?
I did not, Your Honor. Ken Porter alleges that the reason involved his military service. It was a motivating factor. The defendant never deposed him, did not get a declaration, and did not obtain an affidavit from Stuart Scott, who is no longer an employee for TSA. He works for the Federal Aviation Administration. The record is completely devoid of any input from Mr. Scott controverting Mr. Porter's allegation that his military service was a motivating factor.
Well, don't you have to show some linkage to Mr. Scott? The anti-military animus?
The linkage to Mr. Scott was Randy Zender's comment to Mr. Porter that, well, you do a lot of military service. That is the link to the decision.
Well, if we look at the cases on stray remarks, you do need to link that comment by Zender to the decision itself, the decision makers, right?
Yes, ma'am.
And if you don't have testimony from a decision maker, isn't it requiring speculation?
I don't believe that it is, Your Honor, because again, Randy Zender was a recipient of that email. Randy Zender was a 36-year employee of the airline. He was in positions of management. He had a position that placed him in the know as to why the decision was made. And he specifically informed Captain Porter that one of the reasons was because of his military service. Randy Zender was a speaking agent for the corporation, for the company, and he explained to Captain Porter why the decision was made.
Wouldn't Zender's statement be inadmissible hearsay?
I don't believe so, Your Honor. It's a statement against party interest. And as far as to what Mr. Zender says about the conversation, he simply claims a lack of knowledge. He doesn't recall it happening, and that's at his in his declaration.
But he doesn't deny it.
He states that he personally never used Ken Porter's service membership as a basis for Randy Zender to not make a decision to not promote him. However, the question is, why did Stuart Scott make the decision to not promote Ken Porter? Randy Zender says the reason that Stuart Scott, one of those reasons, is because of his service membership.
Who was selected over him? Who was selected instead of him?
Interestingly enough, at the 30B6, the evidence that we solicited was that they don't know. And if you look at, there are 6 different declarations from folks in the know, CEOs, CIOs, VPs. All of them state that they don't know who was actually promoted to the position. And then the deposition transcript is that they have no idea which employees were recommended and which employee was ultimately selected for the position, which is interesting because there was an email that was sent out regarding who was recommended. It was Captain Ken Porter and only one other individual. But the record shows that the TSA was not even aware of who was recommended. The email itself in the record is redacted. We attempted to ask about who was actually promoted at the 30B6, and we were unable to obtain any information from the witness about who was actually promoted to that position.
What do we do with the evidence that the reason was actually Mr. Porter's attitude and criticism of TSA?
The first that I would say about that, Your Honor, is one, this case was not decided on that issue. The court actually stated that Mr. Porter failed to make his prima facie case, which under USERRA, it's actually not called prima facie, it's called your initial burden. And the court decided that he didn't make his initial burden of showing of military motivation behind the decision. But if we were to take that step, the issues that I have with it, again, are that we have 6 declarations from 6 different people in positions of authority, all of whom say they don't know, they don't recall what happened. The other thing that strikes me as odd about the standard, he wasn't worthy of being promoted to a management position defense, is that there were only 2 pilots from a group of over 100 pilots that were on the short list for this promotion. It was Mr. Porter and one other individual. So it's difficult to conceive that a jury would think, well, he's one of only 2 pilots that's on the list of consideration, but he lacked the qualifications to be a manager. And then the reality is that when he left Trans-States Airlines, he went to work for a legacy airline, one of the largest airlines in the world. And his career there is stellar. It does not reflect at all the characterizations that TSA made about him.
Is that in the record?
It is at his declaration at paragraph 25. He states that almost word for word that his career with United Airlines does not even remotely reflect what TSA had to say about him.
I thought the district court actually reached the issue of whether TSH had shown legitimate reasons.
It's an interesting order in that respect, Your Honor. What she did was said that he didn't meet his initial burden. And her basis for that was that these were stray remarks, and it's only based on his sworn testimony, which is not enough to make it to a jury trial. She then addressed and gave treatment to TSA's defenses and, extolled the virtues of TSA and what a great company they are to service members. But the ultimate decision that we're addressing here today is whether or not this statement from Randy Zender is sufficient for Mr. Porter to have made his prima facie or initial burden showing that his military service was a motivating factor.
Well, as I look at the order, it appeared to me that she imposed the Title VII standard on how you assess the defense, which I think, is that correct? Is it the same?
The first part of your question, Your Honor, is yes, that is correct. She did impose Title VII standard to the defense. The answer to the second part of your question is no, it is not the same. It is very different. And
it's the burden. The burden's different, right?
Burden is absolutely different. Under McDonnell Douglas, under Title VII, the burden shifts to the plaintiff once a defense is asserted. A defense that there was another reason, another valid reason, is sufficient under Title VII. Under USERRA, the burden never shifts back to the plaintiff to disprove the defendant's case. And there are two steps to that test. It is not just there was another valid reason. There is a second required element, and that is that also his service membership had nothing to do with the decision. And that's where this case falls short, is that if we have someone in a position of authority saying, well, you also do a lot of military service, you can't accomplish that second element of the defense. So yes, Title VII, McDonnell Douglas burden shifting is completely different than USERRA. USERRA is a much stricter statute, and it was written that way on purpose.
Are there any cases that apply McDonnell Douglas to USERRA claims?
There are a lot of cases where district courts get a bit confused along the way. The courts have said that that's okay so long as the test is applied appropriately. In this case, it didn't. It wasn't applied appropriately. It was a default Title VII case. We look at their defense, we look at the things that they say about plaintiff, and we just say, okay, it's good enough. It wasn't appropriate. If you read the order, the analysis was not properly applied in this case. I say that to say this, to answer your question, Your Honor. If the court had talked about and deferred to Title VII issues, but then actually applied the USERRA elements properly, that has been accepted by courts. It's not acceptable to reference Title VII, apply Title VII, and disregard USERRA's additional element of they must prove that the service membership had nothing to do with the decision. If there are no more questions, I'll reserve my remaining 2 minutes for rebuttal.
You may. Let's hear from Mr. Swissler.
Good morning. My name is David Swissler. I represent the appellee in this case, Trans States Holding Inc. May it please the court. Appellant raises 5 issues on appeal. The lower court did not view all evidence in the light most favorable to Mr. Porter. The lower court failed to liberally construe USERRA rights in favor of Mr. Porter. The lower court wrongfully applied the McDonnell Douglas burden shifting standard. The lower court adopted TSH's pretext defenses wholesale, and that the lower court refused to submit the factual issue of intent to the jury. The law and the facts support the district court's order, and we ask that the district court be affirmed. In short, and I think we've heard this today, Mr. Porter is asking this court to find that a single comment by a non-decision maker made at an undetermined time, unrelated to a specific alleged adverse action, is sufficient to survive summary judgment. Appellant is also asking this court to find that the question of employer intent.
Excuse me.
Yes.
Part of the stray remark analysis depends on linking that remark to the decision itself, right? And here, as I understand it, the evidence is that Mr. Zender was privy to the reasons for the decision. He's on the email chain, and he told, in response to a question about why wasn't I promoted, he said, you do a lot of military service. Isn't that enough to provide the link between the remark and the decision?
Your Honor, I don't believe that it is, because those are two unrelated conversations. With regard to the email chain, the only reference in that email to a negative trait of Mr. Porter is that he's an Alpha ALPA hothead. There's no discussion of his military service in that email exchange on which Mr. Zender was CC'd. And he wasn't the decision maker, so I don't think Mr. Zender can speak to what Mr. Scott actually determined. Mr. Porter testified that he doesn't know who made the decision. And then with regard to the alleged comment, Mr. Porter's specific request is, I asked Randy Zender in his declaration why I kept getting passed over for promotion. Again, this has no nexus to which promotion he sought, because he was seeking promotions for 3 different positions. There's no timeline on which this conversation was made, and there's nothing in the record that shows that Mr. Zender ever had that conversation with Mr. Scott. So I don't think that it's direct evidence of what Mr. Scott decided was appropriate for making the promotional decisions.
Are you saying that if he had evidence of a remark that indicated a general animus to military service and a lack of multiple promotions, that if he couldn't link it to a specific promotion, it's not enough?
I do think that there needs to be a nexus to the alleged adverse action with the negative statement. I think that has to be connected, because we don't know over a 14-year period when any of this occurred or which linkages connect between any of the singular statement and any of the decisions to not promote. So I don't think by itself, standing alone in a vacuum, that's enough, especially when it was made by a non-decision maker.
If the company had a legitimate reason, temperament, but it also references, as Porter alleges, that his absences because of military service was at play. Does that dissipate or neutralize the legitimate reasons?
Your Honor, I don't believe that it does, because the evidence also shows that the company never denied any military leave and allowed Mr. Porter to take them as needed. The person making the comment was also a military member who took multiple leaves, who was then also multiple times promoted. Mr. Zender was a service member who took leave, who moved forwards in the ranks. So
there's plenty of law that suggests that a person in a protected class can discriminate against another person in that class, right?
That is true, Your Honor. And
so he's not immune because he also is a military member.
But I do think the USERRA case law consistently talks about reviewing any comments in context. And this was not in direct feedback to a specific promotion, and it wasn't made by an individual who made the decision. So I don't think, going back to Judge Timkovich's question, that it dissipates the company's justification. I don't think you get to spend your career, a portion of your career, talking negatively about your employer and then be surprised when they decide not to let you be a leader within that organization.
Well, I think Judge Timkovich's question was, if you have evidence that the decision maker was concerned about your negative comments about the company, but also considered negatively your military service, whether under this statute as opposed to Title VII, that's enough for making out your initial burden.
Yeah, thank you for that clarification. That's what I was asking.
If I missed the question, then I apologize. Again, I think that there still needs to be a nexus to the decision maker. And
My hypo and Judge Timothy's hypo, it was the decision maker.
so
Handle the question as asked.
If Mr. Zender made the decision, would this be enough? Is that the question, Your Honor?
Yeah, the question is if there are multiple motivations. One is we don't like your negative comments about the company. And the other is we don't like that you're absent all the time from military service. If you have met your initial burden under this statute.
I think under USERRA, if you can show that it is a motivating factor, yes, that is sufficient to allow for the case to move forward to the second part of the assessment, which is whether the employer can show that there was a legitimate reason standing alone that the same decision would have been made. So,
and on that second step, the court here applied the wrong burden, right?
I don't agree with that, Your Honor. I believe that, in fact, I know that McDonnell Douglas is never referenced in the decision. So that's surmised by opposing counsel. And if we read this decision, the district court was responding to Mr. Porter's repeated assertion of pretext. The court goes through the proper analysis and says, first, you did not meet your burden. And the court could have ended the decision there. But the court goes further. And the court then says the employer specifically made a sufficient showing that it would have made the same decision standing alone. And the court could have ended it there. But then the court then, in response to plaintiff's argument that this was pretext, goes on to address the pretext issue. And I think the court's language on that is telling, because specifically, let me find the quote just so I don't get this wrong.
Yeah, I'm in the opinion right now, so tell me what you are.
The court specifically says, TSH has established legitimate independent reasons for declining to select Mr. Porter's promotions, then goes on to articulate those. But the court says in regard to pretext, TSH is entitled to summary judgment on his discrimination and retaliation claims for this additional reason. The court never supplanted the Lewis burden shifting. The court responded to and then addressed if the assertion is pretext, they don't establish pretext. I don't think that there's any evidence that there was the McDonnell Douglas burden shifting applied. There was no showing that the court ever shifted the burden of persuasion back to Mr. Porter when it simply responded to the pretext question raised by Mr. Porter.
Well, I'll go back and look at it again, but it looks to me like the court thought Mr. Porter had the burden on that issue. So, I mean, the reason it matters, if we were to disagree with the court about the initial burden, then it would matter whether the court was right and applied the right standard here.
Well, there are cases in which pretext is discussed under the USERRA standard, and one would be Velasquez v. Horizon, and that's 473 F 3rd 11, where the court discusses pretext, and in that case, used pretext as part of the assessment about whether the company met its burden. It didn't shift the burden back to the employee, but it, again, responded to the concept of pretext, and does that negate the employer's proof when it established the legitimate reason standing alone?
Does the record disclose whether there were multiple pilots who had taken military leave that were then promoted? Do we have any? I mean, you mentioned Mr. Zender, but was anything in the record developed that shows that the company routinely promoted military pilots?
Mr. Zender is clearly a very good example, but undisputed facts number 11 and 12 in the motion for summary judgment established that TSA was an employer that was pro-military, that it had run awards and accolades for assisting and providing services to military members in their progression into the airline industry. So I think there is evidence that, yes, this company was not adverse to individuals serving in the military. I don't think the record reflects individuals other than Mr. Porter and Mr. Zender and what their specific paths were. But it's undisputed that this employer was not anti-military. In fact, it was pro-military, being a leader in these efforts.
How does that fit into the analysis?
I believe that much of the analysis talks about statements in context. And if you look at many of the decisions, they talk about who made the statement and what that person's relationship with the adverse decision, if there was one, and the military was. So I think it comes back to this idea of, is the company adverse to the company, to the military? And according to the appellant's argument, they're looking at the third Sheehan factor, which there are 4. And the third Sheehan factor is, was there evidence of military animus? And that's what this is intended to assert. Lots of evidence that shows the company was pro-military. And this one statement alleged that Mr. Zender said, well, you do a lot of military duty, in a non-specific context, shouldn't override the undisputed facts that the company supports the military. And without Mr. Stewart's testimony or evidence, there's no linkage between that statement and the decision to not promote him.
What would satisfy his linkage?
I believe there would have to be some evidence that Mr. Zender made those comments to Mr. Stewart, or Mr. Scott, excuse me. I think there would have to be some evidence that Mr. Scott considered the military leave as part of his decision, but the record is devoid of that. So there's nothing in the record that connects the two.
Do we know which promotion specifically this concerned?
We don't, and that's one of the challenges of a case that is 20 years old, Your Honor. And that's one of the reasons that we raised the issue of latches, was going back to 2006, at which time Mr. Porter was promoted to the position of captain. Then we've moved on. TSA was the employer. TSH, as we argued, should not have been determined to be a successor of interest. So TSH presented as much evidence as it could based upon what TSA actually did. Any further questions on that point? Okay, then I will just conclude. USERRA does provide for protections for the plaintiff. However, as this court referenced recently in Selman, it's not a catch-all statute. And that was the October 21st, 2025 decision, Selman versus Horizon, which the court said it doesn't create another right for disability protection. USERRA has its limits, and the Fishgold decision from the Supreme Court specifically says it doesn't go beyond the purview of the specific statute or provide additional rights outside of the statute. With regard to the issue about whether it's exclusively a issue that should be reserved for the jury, I think the Tarrant court, which is cited by the plaintiff, was determined by the Ninth Circuit to no longer be binding because it wasn't a USERRA case and related to a decision and a law that doesn't specifically have the USERRA burden shifting requirements.
All right, thank you, counsel. We appreciate your arguments. Mr. Mitchell, you had some rebuttal time.
Thank you, court.
Just some quick cleanup, Your Honor. Number one is counsel mentioned the Velasquez versus Horizon Airlines. That is a case out of the First Circuit from 2007. And that case actually addresses a question that I think everyone on the panel has asked so far. And that's that if the statement was made by someone who is a non-decision maker, can it be considered as evidence in a USERRA case? And that case found that it was error for the court to disregard the statement simply because it came from a non-decision maker.
And do you concede that Mr. Zender is a non-decision maker here?
Absolutely not, Your Honor. It's clear that he was part of the decision-making process. That email that is at 365 was sent to him. In-house counsel David J.A. Hayes III then emailed back to Randy Zender and said, why does Ken Porter's name ring a bell with me? So there were conversations about this. Stuart Scott sent.
I mean, I think that email indicates that his input was solicited.
Correct.
But I'm not sure it tells us that he was a decision maker. You know, if somebody contacts me for a reference for one of my law clerks, you know, they've asked for my input, but I'm not a decision maker about whether they hired the law clerk, right?
Correct. But if you were part of the process, which that email would indicate, and you had personal knowledge about why the decision was made, and I asked you and you told me it's because you do too much military service, Mr. Mitchell, then we would have a situation of someone who was clearly, the record shows, was part of the communications and disclosed to me a basis for the decision why it was made.
Where in the record go ahead, Judge.
No, I'm sorry.
Where in the record did you challenge the company's position on lack of temperament, leadership ability?
It's in Mr. Porter's deposition testimony. He spoke about his history with the company. He also, in his declaration at paragraph 25, he directly disputes their characterization of his history with the company. And to that end, Your Honor, that is a blanket statement made in the same declaration from an individual who claims that they really don't remember, right? They don't have any knowledge, they don't have any recollection, but they do remember that he was antagonistic and wasn't management material, which again begs the question, if that's the case, out of all the pilots that they have, why is Ken Porter's name on a short list of only 2 individuals for promotion?
What evidence do you rely on that Mr. Porter had personal knowledge of why the decision was made not to promote him?
So the record is clear that he applied, he was considered, he was not promoted. He asked Stuart Scott, who was the decision maker, why. He was not told a direct answer, and so he asked Randy Zender, who he knew would be in the know.
And what's the evidence that Zender was, quote, in the know? Other than Mr. Porter just thought he was.
That's what Mr. Porter's deposition testimony states, is that he believed that Randy Zender was part of the decision-making process, which is one of the reasons why he directed that question to Mr. Zender when he couldn't get a straight answer from Stuart Scott.
But,
just so I'm sure, is the pension claim is not on appeal, right?
Correct, Your Honor. Real quick to break down the statute, Sheehan factors and how it works. Sheehan gives us factors when we don't have direct evidence of discrimination. Sheehan says, here are the things that you can cobble together in inference. You know, proximity in time, other statements, things that happen. The Sheehan factors are not required factors for a service member to prove discrimination under USERRA. The Sheehan factors is a list of things that you could prove to create an inference. In this case, we don't need an inference because we have a direct statement from someone in a management position saying why. The Velasquez case that counsel brought up does say that it is error to just disregard that statement. Justice Phillips asked about other pilots and service member pilots, and the record is not clear about whether or not other service member pilots were subject to the same type of treatment. But again, as Judge McHugh suggested, it is not enough to simply say, you know, we're really nice to the military. A lot of companies advertise based on their pro-military stance. It's a great position to take, but when you overtly state, well, you also do a lot of military service, then we have a case that presents a question that needs to be submitted to a jury. And what Mr. Porter asks is that this panel reverse and remand with instructions for the district court to allow him his day in court to present these issues to the jury to see who they believe.
Hey, counsel, any other questions from the panel? See none, counsel, you are excused and the case is submitted. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, our second case this morning is 24-3147, Coones versus Board of County Commissioners. Mr. Cooper, you may proceed.
Thank you, Your Honor. May it please the court, David Cooper on behalf of the appellants in this case. This is a wrongful conviction civil rights case and an interlocutory appeal from a denial of qualified immunity. Plaintiff's claims that are at issue in this case are count one, which is a due process violation. There are two parts to that due process claim. The first is a Brady type claim, suppression or withholding of evidence. The second is a fabrication claim, claiming that Detective Michael fabricated evidence regarding a van, location of a van and an alibi defense. Second count is a malicious prosecution claim, claiming that there was not probable cause to arrest, charge, or try Pete Coones for the murder of Kathleen Schroll. I'd like to take those in reverse order, beginning with the second claim first, and the district court erred by finding that there was no probable cause. The undisputed historic facts that are actually set out in the district court's opinion show there was probable cause to arrest Mr. Coones, to charge him with the murder of Kathleen and Carl Schroll, and his conviction for the murder of Kathleen Schroll.
Are we looking at probable cause or arguable probable cause?
Both. But we advanced that argument both in the alternative. But it is the appellant's position that as a matter of law, there was probable cause to charge Mr. Coones with these crimes, and that probable cause existed at the time of his arrest and never went away. And those undisputed historic facts are Kathleen Schroll's dying declaration to her mother, Elizabeth Horton, identifying Pete Coones as the killer. And then immediately following up that call, identifying Pete Coones as the killer, Kathleen Schroll was found dead, lying face up in her living room with a contact wound to the back of her head.
Well, I understand that evidence, but it led to an arrest and conviction. But the theory here is that the decision makers had not been disclosed relevant material evidence that would bear on a finding of probable cause, which is what Brady is all about. And so I think Judge Robinson's order says, well, if the decision maker had the facts, there may not have been sufficient probable cause to make the arrest or the conviction. What's wrong with that?
Well, I read Judge Robinson's case the same way you just articulated, Judge. The argument is, and our position is, and we believe it to be correct, is that there was still probable cause. Considering those additional facts and factors that the plaintiff claims and the court says there's evidence to credit was being withheld, there's still probable cause. And that's what I was going through, which is, again, the dying declaration. Carl and Kathleen were both dead of a gunshot wound.
Okay, we understand the four corners of the warrant and see the evidence that's in there, but how do you account for this, or what weight you put on it? The medical examiner originally ruled murder, and then when was given additional facts, the sorts that we're talking about, not in the four corners, said would have changed his mind. That sounds like had a big effect on probable cause determination.
Well, to answer your question, Judge Phillips, the reasons that that Dr. Mitchell changed his opinion from homicide to suicide has nothing to do with the information available to or communicated by or withheld by detectives Michael or Garrison.
Was it the gunshot residue on the left hand that came in way late?
Correct, but neither Garrison nor Michael were CSI detectives. They didn't collect that. They didn't interpret that. What they didn't do is they didn't ask for follow-on testing of the gunshot residue from the KBI lab. As an aside, that testing would not have been available at that time anyway, but that is not pertinent and not material to the argument that I'm advancing. The argument that we're making is that there still was probable cause, even if you consider these things that were withheld or allegedly withheld, that those things are the KBI check forgery report. That's information not available to or attributable to Detective Michael or Garrison. That was Detective Block's case, and he's been dismissed from the case. So first, it's error to say, hey, to fault Detective Michael and Garrison on the probable cause with respect to the forgery report, which they never knew of.
What about the suspicious activity report with regard to her embezzlement from her employer?
That and the quick trip video are the two items that the court hung its hat on in terms of saying, hey, that in terms of saying that there might not have been probable cause. That's not the appropriate standard. There was probable cause. If you assume those facts to be true, meaning that had Detective Michael passed on the suspicious activity report from the credit union and told and passed on the fact that they reviewed the quick trip video and the quick trip video did not corroborate the statement to the daughter that Pete and Kathleen had an encounter at the quick trip, that doesn't make the probable cause go away. When you add those in, there's still probable cause to believe Pete Coones killed Kathleen Schroll.
Well, I guess the view of the district court was that withheld evidence would have called into question Kathleen's credibility.
I agree with that. But that is not the standard for probable cause. It's the facts and circumstances known to the arresting officer that would cause a reasonable person to believe that the crime had been committed. And crediting the suspicious activity report, there's disputed evidence, but on summary judgment, we have to take plaintiff's version of the evidence, and we do. So the suspicious activity report should be considered in the probable cause analysis. The quick trip video should be considered in the probable cause analysis, and neither of them make probable cause go away. There was probable cause all along, and the probable cause standard does not require that a detective discredit or disbelieve or to give more credit to the suspect's denial of the claim or the alibi witnesses.
I'm perplexed as to why you want to argue probable cause as opposed to arguable probable cause, because it's my understanding that the standard in this context is arguable probable cause, which is an easier burden for you.
I grant you that there is an argument that we forfeited the qualified immunity argument. We don't believe we forfeited that argument, but there's a very practical reason for that, Judge McHugh, which is with respect to the probable cause analysis versus arguable probable cause analysis. That's the difference between no constitutional violation and qualified immunity, because it's not clearly established. The unified government would not be entitled to judgment if the hat's hung on the arguable probable cause standard as opposed to the probable cause standard.
Thank you.
Does it matter that the suppressed evidence flowed through into the trial as opposed to just the probable cause for the initial arrest and preliminary hearing?
On the Brady claim, it does. And long story, well, and the jury knew this case was tried twice. That evidence was admitted in both trials. Both juries convicted Carl of Kathleen's murder, knowing that quick trip video existed.
But they didn't, at that time, the jury didn't have, did they have the suspicious activity, the embezzlement information?
No,
at
that's
the
all
second
post-trial.
trial? And they didn't have the gunshot residue on her left hand either, right?
That's all true. All of that evidence
Forgeries.
emerged during the 1507 or the habeas corpus proceedings that got the conviction vacated in 2019. So that evidence was not evidence known at the time for the. I'm burned more than half my time with respect to that argument, and so Judge McHugh, coming back to close the loop on the arguable probable cause, we do argue in the alternative, the easier standard of arguable probable cause, which would give both Michael and Garrison qualified immunity from the malicious prosecution claim, but it would leave the underlying claim, the Monell claim against the unified government, standing. With respect to the Brady claims, because I separate the Brady and the fabrication claims, but let me address the fabrication claim first because we're going to run short on time. First off, that only involves Detective Michael, not Detective Garrison. And that's undisputed by plaintiff in the briefing. So she at least is entitled to judgment on that claim as well. With respect to the Brady claim, there's two asks here. One is the district court made an error on the materiality determination because there's 12 pieces of withheld evidence that was argued on the 1507, the habeas claim. Only two of those lie at Detective Garrison and Michael's foot. And that's the FBI forgery report. Well, the court determined the FBI forgery report, which was unknown to them, and the fact of the Quick Trip video. I think it's legal error for the district court to have concluded that was withheld evidence because it wasn't withheld. That evidence found its way in front of the jury in both trials. So I don't know why that should be considered in part of the materiality determination when it was in fact not withheld. Now, they don't have the video. They couldn't, but that's a failure to preserve claim, not a withholding claim. So that's the first part of the ask, and that's the legal question there. There's a deeper issue with respect to the scienter requirement or the bad faith requirement that we argue should and has to be applied to a Brady claim or a due process claim under both Brady and the Youngblood standard. And that argument is simple, which is the United States Supreme Court has always said, and all the circuit courts agree, that the Brady obligation is an obligation on the prosecutor, not the police officers. And when you apply Youngblood and Daniel, they say on their face that when you're trying to make a due process claim for money damages under 1983 and trying to lay that constitutional violation at the feet of a police officer, there's got to be evidence of bad faith on the part of the police officer, which is lacking here. Now, I acknowledge the Bledsoe case. I acknowledge the Gilchrist case where this court has said you can make a Brady claim, but the argument is and remains that is that decision, those cases, first, they're on motions to dismiss, not summary judgment. And second, neither applies or requires a bad faith requirement, which Youngblood and Daniel say is required for a due process claim against police officers.
Well, we require recklessness at least, right?
And which I believe is the legal question here, that there's no evidence here of recklessness.
Didn't Judge Robinson say that was a disputed fact at this point? Bad faith.
I think she said that on listing out the facts, and she says from those facts, I think a jury can conclude. So I want to be clear that I am aware of the fence, which side of the fence I have to be on.
Right.
I accept the facts. I don't accept the legal conclusion that a jury could reach the decision of recklessness.
Okay.
I see my time's expired.
I'm confused by that, because one case that you don't cite in your brief is Johnson versus Jones, or that line of cases that says if the district court finds a genuine issue of material fact, we're not touching that unless there's a exception, which are difficult to meet, which you haven't argued. And so if the district court says, I find a genuine issue of material fact on that, that's just game over, isn't it?
I disagree with the applicability of that.
Why haven't you cited Johnson versus Jones and dealt with that?
I don't have a reason other than I'm focusing on the issues that I did focus on, Judge. But to address your question as to what the Judge Robinson found that there were material disputed facts with respect to whether Thad Jones did or didn't actually give them that suspicious activity report and whether they knew that. We accept that as a fact. But when you spot the fact that, all right, we accept that as a fact, that still doesn't get over the threshold of recklessness, because for the arguments that we did make in the brief, which is even considering that the materiality of that evidence would not have been apparent to either Michael or Garrison at the time, and for that reason it's either not a due process violation, or at least the law is not clearly established in that regard.
All right, your time has expired. Let's hear from Mr. Ainsworth.
May it please the court. What was known to the defendant officers at the time that the preliminary hearing was held was that there is no sign of forced entry at the house. There's no sign of a struggle. Nothing was stolen from the house. Kathleen was killed by her own gun, which was left at the scene of the crime, lying by the left side of her body. Kathleen was left-handed, which was known to the defendants, as Judge Robinson noted in her opinion. There is blood spatter only on Kathleen's left hand. DNA testing on the gun revealed that there was only one person's DNA on the gun. That was Kathleen's, including on the barrel of the gun and on the trigger of the gun. Also known to the defendants was that at the time that Kathleen was killed, she was embezzling thousands of dollars from her employer in a very not sophisticated plot that was soon to be discovered, including the Friday before she was killed. She took a check out of her bank so that it would not be drawn upon her account, and that was soon to be revealed. Immediately upon her not showing up to work, the plot was revealed. She died on April 7th. By April 9th, a report was created by Thad Jones documenting the embezzlement scheme, how it went about, how she tried to cover it up. That suspicious activity report was provided to the defendants on April 14th, and that was known to them. What was also known to the defendants, if you take the facts as the court must at this juncture, in the light most favorable to the plaintiff, was that Mr. Coones' van was at his home and visible to defendant Michael when he came to the home the early morning hours of April 7th. When Detective Michael testified that he could not see the van where the ruts were, he was providing false information. If you accept plaintiff's allegations to be true, which the court must at this point. All of these facts come to the conclusion that there was probable cause for Mr. Coones' arrest, But following that probable cause dissipated. And certainly this court could not conclude that no reasonable juror could find that probable cause dissipated. And under the Pierce case, which was argued before Judge Timkovich, and the Deloach case, as well as others, probable cause can dissipate when and an officer can be held liable when information material to that probable cause determination is withheld or fabricated, thus contaminating the process. And so it's no use saying that there was a probable cause finding when the defendant officers manipulated that process.
Is that an objective standard that we would determine de novo, whether there was, even with the excluded evidence, whether there was still probable cause or arguable probable cause?
So it's a mixed question of fact and law. The question of fact is determined by Judge Robinson below. This court would review the legal issue de novo. And here below, the defendants made no separate argument about arguable probable cause. And we point that out in our brief. In reply, the defendants have no explanation for why they did not forfeit the argument about arguable probable cause. They made the same argument about probable cause. They made an argument about probable cause, and then in regard to qualified immunity, they simply repeated the boilerplate law and didn't touch the issue.
But why shouldn't we, as a panel, find probable cause here, even after reviewing the record as a whole?
Because probable cause, as this court's Deloach decision notes, is a quintessential jury question. Whether the evidence adduced was sufficient to meet the standard of probable cause it's a complex one that requires weighing of the evidence, and it should be left to the jury. And here we have ample evidence that had the court making the decision to continue the prosecution against Mr. Coones, had the court known that Kathleen was embezzling thousands of dollars from her employer, was in severe financial trouble, was about to have that plot be discovered, and that Mr. Coones did not have the opportunity to commit the crime as was represented to the court. Detective Michael told the court that when he was there in the early morning hours, Mr. Coones' van was gone. And we have to credit the record. The record is that Detective Michael testified that the van was not in the place where the family had indicated it would be, which is the ruts. So the whole issue about whether it could have been somewhere else is irrelevant to the issue. Detective Michael testified that the van was not where it was alleged to have been by Mr. Coones and the family. And thus, because of that, the court was under the impression that Mr. Coones had the means and no explanation for why he was gone from his home at 4:30 in the morning on the day that the victim was killed. That was powerful evidence of guilt. And you remove that, and you're left with the only evidence on one side of the ledger is Kathleen's dying declaration to her mom, not to 911, in which the very first thing she says to her mom is that Pete stole the lawnmower from our house. I mean, that was her very first statement in the call when Pete was supposedly in the home killing her husband and herself. And then you find out that Kathleen is killed with her own gun, which was left at the scene of the house with her DNA on it. We can have arguments all day long about whether it suffices or not, but this is an interlocutory appeal. No reasonable juror could look at these facts and say, without a doubt, their probable cause continued, even knowing that Kathleen was embezzling money, had reason to kill herself, that Kathleen had been lying about Pete Coones's threats to do her harm, and that Pete Coones' van was actually at his home at the early morning hours immediately after the crime was committed. He was a 50-year-old guy with no criminal history. There is plenty of reasons that a jury could find that that probable cause had dissipated.
Are you relying on Pierce versus Gilchrist for the malicious prosecution claim as clearly established law?
That's one of the cases. Also, the Deloach decision, which cites a number of other 10th Circuit cases, including Stringer and Marland.
What's the clearly established case for the due process claim?
For the due process claim, Bledsoe is one case that says as of 1995, it was clearly established that officers could not withhold evidence or fabricate evidence. And this case arises in 2008. There's a line of cases from the Johnson versus City of Cheyenne that cites a number of decisions talking about a police officer acting with deliberate or reckless intent can be held liable, including Tiscarino, which I think Judge Timkovich was also argued before, Your Honor, and the 10th Circuit's Weber case. And so may I move to the due process claim?
You may.
Thank you. So there's a few things to say here. The Supreme Court's Daniels decision simply says that negligence is not enough, which is undisputed by any court. The 10th Circuit has a long history of case law that says all that a plaintiff need prove is that the intent, the scienter requirement is that the officer acted recklessly, which Judge Robinson noted in her decision at page 37, which the defendants ignored wholly. And she cited a number of decisions, including the Johnson decision, and the cases cited therein, that the defendants ignored wholly. This is the first time in this argument that the defendants have acknowledged that Bledsoe and Gilchrist argue against them. And the fact that those decisions are decided on a motion to dismiss standard rather than summary judgment is a distinction without a difference. We're talking about the legal standard to be applied. It doesn't change at the motion to dismiss stage or the summary judgment stage. This is well-settled law. There's no argument to the contrary. And we have, in regard to the materiality analysis, the district court determined that standing alone, the SAR report was material. It allowed the prosecutor to say that Kathleen had no reason to do anything other than keep on living. And Mr. Coones had nothing to rebut that argument with. And because that was material, all plaintiff need to show is that the Quick Trip video was withheld by the defendants. He need not show that the Quick Trip video was independently material to the outcome because we assess materiality cumulatively. And we get that from the Supreme Court's Kyles v. Whitley decision. The 10th Circuit has adopted that same analysis and so and certainly it was withheld. And we're not talking.
Didn't the officers testify about the video at trial, though?
Yeah. So Detective Michael testified about it, but there's a line of cases. So look at Old Chief, the Supreme Court's decision, Old Chief, that says a prosecution does not have to stipulate to facts that the defense doesn't want it brought in. The plaintiff may bring its case to the jury in the ordinary and natural way they would like to do. Meaning that if you have the best evidence, you don't need to rely on a stipulation. You don't need to rely on what somebody's saying about the evidence. You can present that evidence itself as the best evidence. And certainly the jury knew from Detective Michael's testimony that he had viewed this video, but if I'm trying the case as a criminal defense attorney, I want that video. I want to show without a doubt that what Kathleen and her credibility was crucial to the outcome of this trial. What Kathleen's threat statement, talking about a threat that happened 2 days before she was killed, was false. And this was a closely balanced trial. They convicted Mr. Coones of Kathleen's murder, but acquitted him of Carl Scholl's murder. And so you have a divided jury, and anything that could have tipped that balance is Brady. And
we disagree with you about the video. Do you still have enough evidence to prove a Brady claim? Enough withheld evidence? Yeah.
Yes, because Judge Robinson, she found that the suspicious activity report was independently sufficient to be material to the outcome of the trial. And that's unassailable. There's no way you can look at the facts in this case where the defense is trying to present evidence, trying to argue that Kathleen killed herself. The prosecutor says she had no reason to kill herself. And there's every reason in the world when she's facing a felony, indictment, and she's got financial hardship that was unknown to the plaintiff, to Mr. Coones during his criminal case. That is materiality, because it could have changed there's a reasonable probability that the outcome would have been different. This court doesn't have to decide that with certainty it would have changed the outcome, but solely that no reasonable juror could find with certainty that it would not lead to a reasonable probability of a different result at trial. And that's a hard standard for Mr. Cooper at this stage of the proceedings. We were supposed to go to trial in November 2024. This appeal has delayed that trial. I think we now have disputes of fact. Both sides are saying very different things. The only way to resolve those factual disputes is at a trial. And, the law is clear. If there are no further questions,
Thank you, counsel. Mr. Cooper, if you want 90 seconds, I'll give you a little bit of rebuttal since we ate into your time.
Judge, I really only have the closure is the prayer, which is that Detectives Michael and Garrison didn't violate Mr. Coones' rights by withholding exculpatory evidence, or at least in the alternative, it's not clearly established. There was probable cause. We don't believe we forfeited the qualified immunity or the arguable probable cause standard. Those are addressed in both the opening and reply briefs, and Stonecipher itself is quoted in the reply brief as well. And then with respect to the fabrication claim, which we didn't address in any depth, I do need to address the fact that the facts are set forth in Judge Robinson's opinion as to what Detective Michael said and didn't say. And he did not say that the van was not at the house. What he said was, if the van was where Pete Coones says it was, I wouldn't have seen it from where I was standing. So those are my closing remarks. I regret we didn't get to meet in Denver, and thank you for your time.
Thank you, counsel. We wish we could have been in Denver also. You're excused and the case will be submitted. All right, we're going to do one more case, and then for the rest of you listening, we'll take a break after this case. And if everybody is ready, this is 24-3185, KetoNatural Pet Foods versus Hills Pet Nutrition. Mr. Burt.
May it please the court, Your Honor, Thomas Burt for Plaintiff Appellant KetoNatural. This case concerns an extensive campaign of commercial disinformation. The claim is under the Lanham Act. In this case, the district court below made two determinations on a pleading motion, which this court reviews de novo. And both of those determinations were error because the court applied an incorrect standard. Those determinations were that the statements at issue were not commercial speech, and that there were no false statements alleged. If the court affirms, Your Honor, it will have both public policy and also jurisprudential consequences. The public policy consequence is that an affirmance here would create a fairly broad immunity for a marketing executive or department to decide that their best tool was a campaign to say that their competitors' products were dangerous, even if there was no reason or basis to say that, and that they could escape liability for it if they were careful to make sure that by saying that, they avoided fora that looked like traditional ad campaigns.
Is it your understanding that the district court rejected the establishment claim doctrine?
Yes, Your Honor. The district court told us at page 27 of its opinion that what we had to do was prove that the dog food did not cause the disease dilated cardiomyopathy. That's wrong in two respects, one of them much more important than the other. It's wrong in that the district court got its language crossed up between causation and correlation, but that's not actually the important way in which that determination was wrong. The important way in which that determination was wrong is the court did not recognize that the statements were of the kind where what we have to show is that the research does not support the thing that the speaker said the research supported. And Your Honor, I think this is easier to understand if I focus the court's attention, which frankly, I don't think I did as good a job as I needed to at the district court level, on a few statements. So I'm just going to point the court to three.
Let me interrupt before you do. This circuit has not yet adopted the establishment claim doctrine. Is that correct?
Not squarely, Your Honor. There are 8 circuits that have looked at it, and all of them have said, yes, that's the law here. Some of them have found on those particular facts that the statements didn't qualify, but they've all looked at that doctrine and said, yes, that's the law. If this court were to decline to do so, it would create a split in the circuit, which was the point I was moving to.
If we did decline to do so, would that undermine your criticism of the district court? In other words, would you then say, well, maybe the district court was right if you're going to go ahead and reject that doctrine, which you shouldn't?
Not quite, Your Honor, but that's really a significant component of our falsity argument. I would say, as we did in our briefing, that since correlation is just math, studies that show an absence of correlation show no correlation, not merely that they have not shown correlation, if I've phrased that properly. So I think that the scientific literature has not found correlation means that it has found not correlation, which would be different from causation, right? Correlation in that way is simply math. So that the statements about linked, associated, correlated would still be false. But I acknowledge the importance of establishment claim doctrine, what we're going to say. I wanted to have the court look at the statements at 203 of the complaint. We have established the link between diets like these. I'm omitting a few words. If you are feeding the dog one of these diets, talk to your veterinarian about switching. At 207 of the complaint, by now, most veterinary professionals understand there's a link between BEG diets and atypical dog breeds developing DCM. And the one at 154D of the complaint, research has shown that these diets are commonly grain-free commercial dry diets. Most dogs with dilated cardiomyopathy have been eating non-traditional diets for over a year. And I omitted a couple of words from that one.
So the establishment claim theory is a theory to prove actual falsity, right?
Yes, Your Honor.
Okay, I'm not sure that you've preserved a claim for true but misleading. If we're focused on falsity right now, you want to disabuse me of that?
Well, Your Honor, I want to say two things about that. First, that if the court decides that we are in the land of true but misleading, which is sort of only different in gradation from false by necessary implication. The only real difference for our purposes between those two doctrines is that the latter requires that we show the impact on the actual consumers, and the complaint pleads that my client did an actual survey to show that. Under those circumstances, the court has reserved to itself the right to still review it because we made closely analogous arguments under a plain error standard. And if it's just applying the wrong standard to what we have to plead about the statements, I think the court should take the opportunity to do that, whether or not it's preserved the way it should have been.
Okay, thank you.
So, Your Honor, I want to also point the court to the three nevers of the research. And we are not picking a fight here with the peer-reviewed research, which makes this different from, for example, ONY and its progeny. There has never been a case that shows a correlation between a study that shows a correlation between BEG or a group of them dog foods and developing DCM, or a correlation between dogs eating BEG or grain-free foods and living shorter lives. And there's never been a case that shows that a dog that already has dilated cardiomyopathy will improve its condition from dietary change alone. So this is a little like Alpo when then Judge Thomas said you can't say that your dog food will treat hip dysplasia if there is no empirical basis to say that. We are in the land of statements that assert or by necessary implication tell the listener. Science backs me up on this. The research has shown, studies prove.
Do any of the academic articles reference any particular pet food?
I cannot point to one that references a particular brand. So, Your Honor, I wanted to address that in light of the commercial speech prong, if I may.
And that's where I'm focused.
My friend at the other podium spent a lot of effort in the briefing on the second prong, saying, well, there's no direct attack on KetoNatural specific product. And of course, this is a class case where the class of dog food makers includes everybody swept within the defendant created category BEG. The cases do not indicate that the brand is how one assesses the second prong of the Bolger standard. In fact, P&G in the Fifth Circuit P&G in the Fifth Circuit has brand name but no category of products, whereas Bolger itself has category but not brand name. And
does it matter who the speaker is? If you don't have a specific reference to a product, you might still have a claim, but I think the cases would suggest that that depends on who the speaker is. Would you agree?
It absolutely depends on who the speaker is, Your Honor. And by that, I don't mean whether it's Hills or one of its co-conspirators. The court rightly said, though I think it backed off it when it addressed the statements, that it was assuming without deciding vicarious liability. But who the speaker is in terms of whether the speaker is a direct competitor is tremendously compelling. If there's one factor, and Bolger does say that no one factor controls, if there is one factor against which all of this is read, the question is the speaker or the conspirator putting out the statements a direct competitor of the people they're speaking against? What we have here, Your Honor, the complaint pleads that Hills identified a group of foods that was taking its market share and decided we have to say something really bad about all of those products to claw back that market share. Direct competitors, the touchstone in the case law of commercial speech, that factor alone is not enough, but they are read holistically as Bolger itself and P&G in the Fifth Circuit tell us.
Is there any evidence that the academics were compensated depending on the results of their articles, the conclusions of their articles?
No, and again, Your Honor, we are not picking a fight with peer-reviewed science. We are not saying that they used bad data or applied torque to the conclusions they reached. In fact, ONI tells us that the peer-reviewed science and the results, but only that, right, are protected. What we are saying is if you actually look at what the studies say and not how they are described in retransmission or in re-reference or when they're referred to by Hill's own veterinary education, the actual results of the study never show that there's a correlation between these foods and this disease. The peer-reviewed science backs my client up.
So I guess what my focus is, I see a big difference between the veterinary blogs and public media quotes and Hill's own website and Hill's educational programs, because to me, if you look at these cases, it is critical who's speaking.
Well, Your Honor, I think that reads the conspiracy allegations out of existence. I think none of those cases address a circumstance where there's an actual pleading of conspiracy, and here there is. The district court did not decide whether the conspiracy was properly pleaded. What we have here, every statement is made by an alleged conspirator. And if the district court wanted to decide that pleading didn't hold, it needed to do that below. Since it said it was going to assume without deciding that Hill's is vicariously liable for every statement made by a co-conspirator, that's not an issue the court should address on that appeal, on this appeal. If the court doesn't have further questions, I would like to reserve the balance.
May? Mr. Panikowski?
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. Stanley Panikowski for the appellee, Hill's Pet Nutrition. The district court's judgment should be affirmed, Your Honors, for at least one of two independent reasons. First, KetoNatural did not plausibly allege commercial advertising or promotion. Second, KetoNatural did not plausibly allege false or misleading representations of fact under any doctrine. Both of these are essential elements of a Lanham Act false advertising claim. So the absence of either one supports the district court's correct decision to dismiss the false advertising claim with prejudice.
Let me start with falsity.
Yes, Your Honor.
If we were to adopt the establishment claim doctrine, would they be able to make out falsity here?
No, Your Honor. KetoNatural would not be able to plausibly allege falsity, even if this court recognizes the establishment claim doctrine. And that is because most—
Why not? I mean, it seems to me that they are representing a conclusion from the studies that the studies, and certainly the FDA investigation, does not support.
Your Honor, the establishment claim doctrine, as articulated by the Eighth Circuit in the Roan Poulenc case, has a specific requirement that those types of statements are statements about the quality or characteristics of a product, beginning with a phrase like test proves, studies show, or some other phrase that means the same thing. And here, Your Honor, we don't have any alleged statements that fit that bill. Most of the statements do not even have anything such as research shows.
Pause there, because some statements were identified earlier in the argument, and on page 38, 39, those show up, or at least some of them. Research has now shown. The FDA has identified marine correlation. Many have linked diet-associated DCM, blah, blah. In other words, I don't know that you can say what you just said.
Your Honor, taking that first example, the research has now shown, first, it does matter who the speaker is, and this is not a statement that was made by Hill's itself, but setting that aside, Your Honor, what this statement is talking about is research has now shown some general proposition about the state of the science here. It's not like the other establishment claim cases that KetoNatural cites where there's some direct comparison between two specific products or a statement being made about a particular product.
But there is, because, it's the research has shown if you feed your dog these, they're the natural products, that you're going to give them a heart disease. I mean, the research doesn't support that, does it?
Your Honor, when you look at this statement, and the allegations of the complaint, there were the case reports that were made to the FDA. There were 515 cases that were reported. The FDA itself said that over 90% of those reports were for grain-free diets, and you had the FDA itself launching the investigation, holding scientific symposia, reporting updates. So the statement, research has now shown that these diets are commonly grain-free commercial dry diets that contain pulses and to a lesser extent potatoes or sweet potatoes, is simply a characterization of the case reports that were submitted.
The allegations here are that based on this conspiracy, they intentionally only referred cases to the FDA that were dogs who were eating their competitors' food. I mean, I think, like Judge Phillips, that if we recognize an establishment claim doctrine, there's enough here to get over the hump.
Your Honor, with respect to the issue of conspiracy, that's again where it's very important to analyze who is speaking here. Because
are you arguing that, before you answer, that we should not adopt the establishment doctrine?
No, Your Honor. Hills is not taking that position because Hills believes that KetoNatural has not plausibly alleged literally false establishment claims anyway, for the multiple reasons we stated in our brief, some of which we've discussed so far, that this court can assume for the sake of argument that that doctrine is being adopted. If the court were to decide to adopt the doctrine, I think what is important here is to limit it in the way that the Eighth Circuit did in Roan Poulenc, because KetoNatural's argument would essentially use the exception to swallow the rule and would convert every statement about the state of the science, about the characteristics of a product, about a comparison between two products to an establishment.
Does their civil conspiracy theory, does that solve their who the speaker is problem or not?
No, Your Honor. Their civil conspiracy claim does not solve who the speaker is problem for three reasons. First, when you're looking at the first reason why their claims fail, commercial speech, you don't have any issue there in terms of it mattering whether a certain defendant is vicariously liable for the statements of others, because when you're looking at whether the statements constitute commercial speech, you're looking at factors like, is it an advertisement? Does it refer to a specific product? Is there an economic motivation? Vicarious liability does not come into play here. Second, Your Honor, there's a circularity in KetoNatural's vicarious liability argument. For civil conspiracy under Kansas state law, cases like Mays and Stolt, you need to plausibly allege and ultimately prove at least one overt unlawful act in furtherance of the conspiracy. Here, the only predicate act that KetoNatural has identified are Lanham Act false advertising violations. And then KetoNatural has said in its briefing on appeal that it is relying on civil conspiracy alone to show vicarious liability. Therefore, you have a circularity there where you cannot use the Lanham Act violation as a predicate act for civil conspiracy and vicarious liability until you've actually shown a Lanham Act violation. And therefore, KetoNatural is limited to show that predicate act to the statements by Hills itself. And Your Honors, when we look at the complaint, we find very few statements that are alleged to be made by Hills itself. And if we look at the two that the complaint highlights, we have at pages 441 to 444 of the appendix an article on the Hills website, Cardiomyopathy in Dogs, What You Need to Know. And KetoNatural does not allege that Hills made any false or misleading statements in that article under the establishment claim doctrine or otherwise. Rather, there's a sentence in that article which talks about a number of topics, not just nutrition related to DCM. And it says, referring to DCM, the disease is at least partly genetic, and nutrition may also play a part, according to the University of Illinois College of Veterinary Medicine. And on the academic institution's name, there's a hyperlink then to a University of Illinois article discussing this issue. Your Honors, if this were...
And let me just, in one of those, the alternative proteins in dog food and cardiomyopathy, it actually has a section at the bottom of the page where it advertises specific Hills products.
Yes, Your Honor. There is a portion at the bottom of that page where it says related products and has links to those products. However, Your Honor...
That seems like an advertisement to me.
Your Honor, if those links were looked at in isolation, one would say that you've plausibly alleged that those are links to advertisements. But the focus of the commercial speech inquiry under Bolger and under cases like the 11th Circuit's decision in Tobinick is on the content of the challenge speech itself. So when you look at the statement, for example, that's made at page A469 of the Hills article you reference, some of these trends may even pose health risks to dogs, and that then has the hyperlink to the Tufts University article. In that situation, Your Honor, you're simply making a statement that is identifying a general issue of scientific concern, and then you're linking to an academic article discussing that. If the commercial speech doctrine were to be construed so broadly that the mere fact that later on in that page you have related products, hyperlinks, then you would simply be converting any way in which a for-profit entity communicates with the public, including a potential customer base, into commercial speech simply because there are links on their website. And the 11th Circuit in Tobinick makes clear that that's not enough. In Tobinick, the defendant's blog post on a blog of which the defendant was the executive editor did contain advertisements themselves and did contain links to other revenue generating sites. And the 11th Circuit made clear that those features by itself did not convert the commercial speech being challenged into an advertisement. And if so, you would have the problem where the non-core speech that Bolger identifies as being subject to its three-factor test would always be drawn into the realm of commercial speech.
How would you distinguish Bolger then?
Your Honor, we would distinguish Bolger on several grounds. First, taking the first Bolger factor, advertisements. In Bolger, the Supreme Court expressly stated that the informational pamphlets were conceded to be advertisements. There's no such concession here. And even when you compare the facts of this case with the informational pamphlets in Bolger, apart from that concession, in Bolger, the defendant was proposing to send these informational pamphlets unsolicited directly to consumers. They were classic advertisements, whereas here we don't have that. We have the Hills website. We have a Learn tab where veterinarians and others can go in order to learn more about issues related to pet health and nutrition and scientific issues. And for the reasons we explained in our brief, that website and those articles, and most important, the statements contained in those articles do not constitute advertisements under any reasonable view of that term. Second, Your Honor, when you turn to Bolger's second factor of refers to a specific product. Now, it is, to begin with, important that the Supreme Court use the word specific product. They did not just say product generally. So we have the Supreme Court focusing the inquiry first on, is there a specific product identified in the speech? And then the Supreme Court goes on to identify two exceptional situations. Now, again, we're already in the realm of non-core commercial speech. And so First Amendment interests are heightened. And then here we're getting into a realm that's an exception to a factor that might be an indicium of non-core commercial speech. And what the Supreme Court said is a reference to a product in generic terms may suffice if, for example, the speaker controls such a large share of the market that in referring to that generic product, they're effectively referring to their own product. And in that case, it was Trojan brand condom manufacturers. The Supreme Court found that that element was met. Here, under the terms of KetoNatural's own allegations, at appendix page 21, paragraph 3 of the complaint, the supposedly favored products in this speech about the scientific debate are the products of Hills and at least two larger competitors. And KetoNatural makes much of the fact that Hill's pet food revenues are only 20% those of Purina's. There's no plausible allegation there that Hills would meet that first exception to Bulger's second factor. And Your Honor, the second example that the Supreme Court gives as an exception is a trade association. And it's a trade association's very mission to promote a generic category of products. And therefore, if the trade association is the speaker and they're talking about the generic product, that's enough to satisfy that reference. Obviously here, Hills is not a trade association, does not dominate the market. And we have the problem at the other end, Your Honors, where the allegedly offended products are of this broad class that also includes a number of Hills products. When we look at the FDA case reports, we see at pages A178, A207, 234, 244, 248, 249, that Hills' own products, including a number of Hills grain-free products, are also within that category. Your Honors, I see my time has expired. If there are no further questions, thank you. And Hills asked that this court affirm the judgment of the district court. Thank you.
Thank you, Mr. Panikowski. Mr. Burt, you had some rebuttal time.
Thank you, Your Honor. On the scope of the application of the establishment claim doctrine, I would ask the court to look at the excellent discussion in BASF in the Seventh Circuit, Eastman in the Fifth Circuit, and especially Southland Sod Farm in the Ninth, where there was a bar chart that simply said proof that our product, I'm eliding some words, proof that our product saves time and money. The court said in that context, you're clearly saying that the science backs me up on this. I think while my learned opponent points to one Rome Poulenc in the Eighth, the bulk of the case law on establishment claim doctrine is flexible about what constitutes a statement that the science backs me up on this. I think, Your Honor, the best way that I can put the doctrine is if the speaker's statement is of the nature research shows this, this has to be what the research shows. My opponent raised.
What's your response to his Bulger discussion?
So, Your Honor, we know that the advertising the question of whether it is advertising is read holistically and flexibly because P&G and the Fifth Circuit did that. P&G actually remanded and said, if the district court finds that the statements, and it was a scurrilous allegation of disinformation about the directly competing product made by distributors for Amway, if the statements were made motivated by the attempt to gain a commercial advantage, then the first prong, if it's advertising, collapses with that. I also think my learned opponent has asked the court to render a decision that's directly contrary to the Ninth Circuit and Eric's just a couple of years ago. Eric says we live in the age of the influencer campaign. So those campaigns obviously look different, but they're clearly advertising campaigns. On the specific product, They said specific product, not brand, and I think that means what it says. And I think there are cases in our brief that back that up. If you say BEG dog foods or grain-free dog foods, that's a specific product. And I think the fact that Hills is not an overwhelming majority, is just one of the big three, is explained by the factual circumstance where Hills was the one losing market share to all of these smaller companies and in fact regained it. I've run my time, Your Honor.
Thank you, counsel. Counsel are excused and the case is submitted. We appreciate you appearing today, Mr. Burt, in a museum.
Thank you for your time, Your Honor.
All right, the court will take a short recess. It's 10:41 Mountain Time. We will reconvene at 10:56, 15 minutes.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
All right, welcome back. Our next case is Mukantagara versus Noem, and it's 24-4071. Mr. Black for the appellant.
Yes, thank you, Your Honor, and good morning. Distinguished judges and counsel, may it please the court, my name is Daniel Black, counsel for Appellants Agnes Mukantagara and her son, Ebenezer Shaka. It is correct that there is part of 8 U.S.C. 1157 C4 that does grant to the government limited discretionary authority to exercise mercy and not to terminate refugee status of any alien, but only after the government proves that the alien was not in fact a refugee under the meaning of 8 U.S.C. 1101 A42 at the time of their admission into the United States. That is a legal determination that is not discretionary, and that is what plaintiffs are seeking review of in this case under the APA. The type of discretion granted in 1157 C4 is prosecutorial discretion, the discretion to mercifully not terminate refugee status if they prove that the alien was not in fact a refugee at the time of their entry. Regardless of the order of the language in 1157 C4, it is grammatically a classic if-then statement. If the Attorney General determines the alien was not in fact a refugee within the meaning of section 1101 A42 of this title at the time of the alien's admission, then the refugee status of that alien may be terminated by the Attorney General pursuant to such regulations as the Attorney General may prescribe.
Is refugee status, isn't that a fact question? And how would we be able to review a fact question under the Act?
It is a mixed question of fact and law. And just like in the case that we cited of Wilkinson, mixed questions of fact and law are questions of law. In that case, where the court was determining a legal and factual question of a 42B application, the Supreme Court found that where it was an application of facts to a legal standard, that is a question of law that can be reviewed.
But here, wasn't there a finding that your client was a persecutor, participated in a genocide? That doesn't seem to have any legal component to me. It seems like a quintessential fact question. I don't know. I mean, and then what authority do we have any judicial authority to say, well, even though she's participated in genocide, we don't think refugee status should be withdrawn?
The ultimate decision of whether or not to terminate the refugee status is a discretionary decision, but that's not what plaintiffs are challenging here. Plaintiffs are challenging that legal and factual determination of applying the facts to the law, and the law is the definition of under 1101 A42 of a refugee. There are legal standards within that definition that have to be met with facts in order for that determination of refugee status to be made.
What are those legal determinations that we need to apply in this case?
That someone is outside of the United States, that they are unable or unwilling to avail themselves of the protection from their country, and that from persecution based on account of their race, religion, nationality, political opinion, membership in a particular social group. There are legal standards for all of those, and there's case law for all of those different protected groups. There is case law for persecution. There is a legal definition of persecution and a legal standard to be applied. And all of that is actually done for every refugee applicant that applies for refugee status from outside the United States. And that is a legal and factual determination that is made prior to an exercise of discretion to allow them to enter. But then,
but Section 42 says a refugee does not include any person who ordered, incited, or assisted, in a genocide, to paraphrase it a bit. I don't see what role we would have in reviewing that determination at all.
But that is a determination where, I mean, genocide is also those are specific legal definitions as well that also can be determined, where you're applying the facts to the law of those definitions, both within 1101, 842, and then throughout the INA, where it talks about what those definitions are.
Well, just one follow-up, and then I'll leave it. But are you challenging the determination that your client was a persecutor?
Yes, in addition to the legal determination that the bar would apply, and the constitutional Fifth Amendment arguments that we are challenging for due process, as well as the APA challenge that this was an arbitrary and capricious decision by USCIS. The if clause in 1157C4 introduces a condition precedent to any exercise of discretion. There is no power by the government to exercise any discretion until the agency proves the legal condition precedent of whether the alien was a refugee at the time of their entry. And again, that determination is not discretionary and is subject to judicial review. There are other examples of courts reviewing the application of facts to the law as part of a necessary legal determination. I've already talked about Wilkinson. Another from this court is Sabido Valdivia v. Gonzalez, where this court found that the 10-year physical presence requirement on a 42B cancellation of removal application was not a discretionary question. On its face, that sounds like it's just a pure factual question, but it is not, according to this court, and is subject to review, even though the ultimate grant or denial of a 42B cancellation of removal application is completely discretionary and is up to the discretion of the immigration judge. But when there are aspects of that application that are the application of facts to the law, it is not a discretionary question, and it can be subject to judicial review.
What do we do with the subsequent decisions from the immigration judge and then by the BIA that determined that that the mother was credible and not a persecutor?
Your Honor, that is for the district court to consider in the factual and legal analysis, but the plaintiffs here are actually not challenging anything that happened in removal proceedings or a final order of removal. And this court 2 years ago already decided that, quote, plaintiffs do not challenge their removal proceedings. Rather, they challenge USCIS's determination to terminate refugee status.
The legal, the step one, as you call it, on whether she is a refugee is inextricably intertwined with whether she is a persecutor, isn't it?
Those are two separate questions, yes, within finding if they qualify for the definition of refugee.
Yeah, so I mean, so when we have first the finding that she is a persecutor, and then we've got these subsequent findings that she's not, do we yet have a decision? Because there was an appeal. The government appealed the BIA, the last decision. I guess they remanded. The IJ ruled twice, and it's up with the BIA now. Do we have a decision?
No, it is still pending before the BIA, and the son's case is still pending, is actually on abatement before this court, pending the decision by the BIA, but also pending these proceedings. But regardless of whether or not the BIA upholds the immigration judge's decision or denies, and that goes up to comes up to this court on a PFR, the determination by USCIS will never be part of that case. And that's because the immigration judge decided under BIA precedent that he has no jurisdiction to review USCIS's termination decision. And that was this court's decision as well 2 years ago in this case, that this decision by USCIS forms no part of a removal order and forms no part of removal proceedings. The government continues to assert, without providing any legal roadmap for how this would be possible, that somehow this can become part of the final order of removal and considered by this court in a PFR. But that disregards the statutory limitation in section 1252B4A, which limits this court's jurisdiction to, quote, decide the petition only on the administrative record on which the order of removal is based.
If there's still proceedings pending in the BIA, why do we have a final agency order that we can even review?
This court already said that decision is final because it forms no part of removal proceedings and was not considered by the immigration judge. And so they're completely separate, and is a final order because it is a final agency decision because it was a consummation of the process by USCIS from which legal consequences flow, and there is no adequate remedy in any other court. And that was a finding, that was what was argued previously, and this court already decided that because plaintiffs are not challenging anything in removal proceedings, nothing that they are seeking judicial review on through the APA in this case can be part of the PFR. And so whatever happens with the pending case at the BIA or with the son's case in before this court, those are separate from this judicial review of this decision, which forms no part of removal proceedings. And so, Your Honors, we're asking the court to allow us to hold the government accountable. This is about accountability. If the government adopts if this court adopts the government's position, then there would be no judicial review of their decision anywhere. The only location where there can be judicial review of USCIS's final agency action is through APA review in the district court. It forms no part of removal proceedings and would not be considered on a PFR.
So if the district court found arbitrary and capricious, what happens next?
The district court can restore or order the USCIS to restore their refugee status, and then my clients would be able to still, under the Child Status Protection Act, protect Ebenezer Shaka, the son, from deportation. He is currently exposed and has a final order of removal to Rwanda simply because he aged out. But he aged out because of that arbitrary and capricious decision, and by fixing that, he will no longer be subject to a final order of removal simply because of the passage of time.
I understand how he can be harmed. And is that what this is all about? Does it really affect the mother so much? What happens here today?
It affects the mother's ability to protect her son. It affects the mother's ability to use her status as Congress intended under the Child Status Protection Act to protect her son from deportation, which is how he came into the United States, and she would like him to stay here as well. I'd like to reserve the rest of my time.
Before you sit down, just so I'm clear, if we agree with you and find that it's reviewable and we remand back to the district court, what's your argument in the district court?
That this was an arbitrary and capricious decision, that they did violate due process because my clients were not provided the evidence that the government relied upon, and that the government knew that that evidence was suspect because of its the nature from where it came, and because of the history of the Rwandan government providing that kind of evidence for political persecution, and that all of that needs to be reconsidered and be reviewed by a judge.
I'll give you a little bit of rebuttal time.
Thank you.
All right, let's hear from the government. Ms. Ahmed.
Good morning. It may please the court, Anissa Ahmed, on behalf of the federal government. Your Honors, this court should affirm the district court's dismissal of appellant's complaint for 3 reasons. First, under 8 U.S.C. 1157C4, USCIS has such broad discretion to terminate refugee status that such a termination is shielded from judicial review by Section 1252 A2B2. Second, neither the APA nor the INA requires judicial review, and the Heckler v. Cheney standard does not determine whether 1252 A2B2 precludes review of discretionary decisions. And finally, there is no separation of powers issue here because the statutory text is unambiguous and appellants can obtain the review that they seek through a petition for review, a PFR, pursuant to 1252 A2D. For these reasons, we ask the court affirm the district court's dismissal, and I welcome the court's questions.
Well, let's start with the last one first. You can't get review through the PFR, can you?
You can get review through the PFR. So appellants can't.
You won't have the record, right? I mean, they're separate cases, right?
So appellants can't.
How are they going to get the review that they claim they're entitled to just through the PFR in a removal proceeding?
There are 2 ways. First, just through simple supplementation of the record, appellants can file motions pursuant to the federal rules of appellate procedure, this court's local rules, or federal rule of evidence 201 seeking judicial notice of certain documents in administrative proceedings. So they can supplement the record that way. But another way that they could supplement the record and lodge their challenge to the original termination decision is by challenging the regulation 8 CFR 207.9 itself. And so while the IJ can itself review the termination decision, this court can review any constitutional law issues, including questions of mixed law and fact, under 1252 A2D. And Your Honor, Timkovich asked at the end of your colloquy with Mr. Black that what appellant's arguments are would be upon remand. And Mr. Black argued that they would argue that they weren't given the evidence and that amounts to a due process violation. That's a constitutional claim that can be reviewed under 1252 A2D by way of a PFR.
In reviewing the petition, the PFR, could this court reach a different determination on the issue of persecutor?
It could, certainly, because you would be looking at the merits of that decision. If you found that 8 CFR 207.9 was a violation of appellant's due process rights, which we're not conceding it does, but if you were to find that, you could reach that original decision. The trouble with that,
not the constitutional argument. What about just whether, under the definition of refugee, the decision was correct that she was not a refugee?
Yes, you could, because that would be a question of mixed law and fact, which Wilkinson allows under 1252 A2D. So you could reach that determination. The only problem there would be if this court were to reach a determination that is contrary to the determination that the BIA would make. Of course, this reaches B9 arguments that the government previously lodged, which a panel from this court disagreed with. But just to mention it for fulsome information. I think a discussion of Patel and Boarpa, the Supreme Court's recent decisions on 1252 A2B, would be helpful here to discuss whether or not threshold eligibility determinations are covered under 1252B, and they are. The framework to determine whether or not any intermediary decisions are covered is to look to see whether the ultimate decision is discretionary. If Congress has conferred discretion onto the agency, as it has here in 1157C4, by saying that USCIS may terminate if it finds that a non-citizen didn't meet the refugee definition upon admission. That is discretion, and any intermediary decisions flowing up to that decision are precluded from review as well, and that is Patel. And of course, Patel only dealt with 1252 A2B1, but following Kukana's instruction to read both of those provisions, B1 and B2, harmoniously, we can find that, and including the broader language in B2, which starts with any other action or decision, which is broader than judgment, we can find that any intermediary decision that is covered by B2.
Well, the statute actually ties the definition of refugee to another statute that has statutory definition of refugee with the persecutor exception to that definition. I mean, doesn't that indicate some congressional intent that this is not just freewheeling discretion, instead that they're limited to the first determination of whether or not the mother here was a refugee is cabined by specific congressional definition of a refugee?
So I'll disagree a little bit with that proffer. First, we would concede, of course, there is a definition, and USCIS in terminating refugee status must, of course, find that the non-citizen did not meet the definition of refugee when he or she was admitted. So certainly, yes. However, that Congress has provided definitions throughout the Immigration and Nationality Act does not mean that there is no review ever, because Congress, in writing these definitions, also in the same act created jurisdiction stripping provisions. And so by plaintiff's proffer, anytime Congress wrote any definition, that would essentially eviscerate any jurisdiction stripping provision. And that simply cannot be. And that's not just in the immigration context, but broadly. And so that there is a definition does not mean that there is still judicial review. And again, that would be an intermediate decision and determination or action that is then subsumed in the ultimate discretionary decision for which judicial review is precluded by 1252 A2B2.
And if I understood what you just said, that it would invalidate the jurisdiction stripping provisions if we were to say the reference to a specific statutory definition meant that you don't have full discretion on the determination whether she was a refugee. I mean, there's other statutes where there's no reference to a particular statute. I see those as you've got your jurisdiction stripping provisions are still in effect. So I guess I'm not buying your argument that it would completely eviscerate the jurisdiction stripping provisions if we were to say when Congress ties it to a specific statutory definition, it is an intent to cabin discretion to that legal definition, and we can review.
Again, I would disagree because
it takes the jurisdiction stripping provisions and essentially invalidates them.
I would say certainly in this case, yes, because if we're going to say that there is a definition that exists for a refugee and that any termination decision that USCIS makes that is wholly discretionary, because again, USCIS does not need to terminate if it finds that a non-citizen didn't meet the refugee definition. So it is the quintessential discretionary, the two-way street that Buarfa talks about.
But if they do not, they don't have to, right? But if they do meet the definition of refugee, they have no discretion to determine that they have to be removed, right?
Certainly, and that would be a question of mixed law and fact that can be reviewed, just not here, but through an appeal from the district court's decision. It would have to be through a PFR under 1252 A2D. So eventually, that mixed question of law and fact can be reviewed.
We have a final agency action, as I was discussing with Mr. Black. What's your position on that? That
there is no final agency action here. I know that in Bennett v. Speer, the Supreme Court there said that the issue was the agency and only used a singular term. But here, the question is whether or not there's been a final determination made on Ms. Mukantagara and Mr. Shayaka's immigration status. And here, that's not the case, at least for Ms. Mukantagara. There is no final decision by the adjudicators that would ultimately decide her immigration status. Currently, there is a pending appeal before the BIA. The BIA can affirm, could deny, and if it denies or overturns the IJ, then Ms. Mukantagara can file a PFR. And in that case, there is a potential that this court will have 3 different cases pertaining to the same issues: Mr. Shayaka's PFR, Ms. Mukantagara's PFR, and this appeal. And so there is no final agency action here because there's no finality as to her immigration status. And so we would argue that there's no APA record review here.
But what about with regard to Mr. Shakira? Is there a final agency action with respect to him? I mean, he's been ordered removed, right?
He has been ordered removed, but we would say also pending the outcome of this litigation that there is no final agency. Actually, no, I think you are correct that there is a final agency action as to him.
And so can I ask you a question about the 2-step that Mr. Black's talking about with 1157C4, the first being the preliminary findings required, and then the second being the grace, the discretion. And I want to ask you about this case, which my law clerk dug up. I did not. You may have heard of it, you may not. It's not cited. It's from the 11th Circuit. It's Mejia Rodriguez. You familiar with that?
I am not, Your Honor.
All right. Well, let me tell you a little bit about it. It concerns temporary protected status. And that's exactly what the 11th Circuit does, is the 2-step. And the significance of it being an 11th Circuit case is that both of the Supreme Court cases you've referenced are out of the 11th Circuit. And it's a 2009 case that even after those 2 cases, my understanding is the 11th Circuit still considers that case active and valid, which would suggest to me at least that those 2 cases did not undo what Mr. Black is trying to achieve here, and that the 2 statutes, the 1157C4 and the temporary protected status statute, are similar. And so why wouldn't we rely on that is my question. But I realize I'm just kind of popping in out of the dark. They're asking you about a case you don't know.
Sure. And initially, if Your Honor were to rely on that in your decision making, the government would ask that we provide supplemental briefing to discuss this case, just because I'm not aware of it and we didn't cite it in the briefing. But I will say, temporary protected status is distinct from, without having the statute in front of me, I believe is distinct from the issues from 1157C4. But that's all I can really speak to that. I would still say that in this case, what we're looking at here is just the statute on its face, 1157C4, which says that USCIS may terminate, which allows broad discretion. And it is actually the same language that the Supreme Court in Boarfa found to be broad discretion, such that decisions made pursuant to the provision that was at issue in that case, which was 1155, are precluded from judicial review. So again, without having...
Boarfa, the Supreme Court specifically left open the question of whether a threshold requirement could be reviewed, right? So I don't know that I wish it helped us, but I'm not sure it does to answer the question here.
Sure, it was assumed without decided in that case, and Justice Jackson explicitly said so. However, I'd say reading Patel and Boarfa and Kukana, which are our key cases on 1252A2B together, and again, following Kukana's direction to read 1252A2B1 and 2 harmoniously, does help us here, because 1252A2B1, according to Patel, encompasses all intermediary mandatory and non-discretionary and discretionary decisions that ultimately lead to the discretionary decision at issue. And again, looking at the language of 1252A2B2, which says any other action or decision, means that whatever is covered by 1252A2B1 has to be covered by 1252A2B2. And the Fifth Circuit recently held just last year that very proposition.
And what case is that?
That is Chatterjee versus Lincoln. The case citation is 106, 4th edition of the Federal Reporter, page 388, 5th Circuit, 2024. And specifically, it said that the use of the word action in B2 would be superfluous if the provision only stripped jurisdiction to review only final discrete decisions. Your Honors, I see that my time is coming to an end. If I may briefly conclude if there are no further questions.
You may.
Thank you. For the reasons discussed today and the reasons discussed in the briefing, we respectfully request that the court affirm the district court's dismissal. Thank you for your time.
Thank you, counsel. And Robert, could you give 90 seconds for Mr. Black?
Thank you so much, Your Honors. I would like to let the courts know to address opposing counsel's suggestion that we could simply supplement the record. We did file a motion to supplement the record in Ebenezer Shaka's PFR case that is currently pending before this court, and the government opposed that. And it was denied as part of the abatement of that case. And so I don't see any legal way that it can be accomplished what the government is suggesting. I would like to also just address Patel quickly. Patel, 1255, the statute that they were considering there, is clearly discretionary, but also is listed as under 1252A2B1, one of the types of cases that is precluded from judicial review. And so it is distinguishable from this case. Notably, refugee status is not listed anywhere in that list of cases that are for preclusion of judicial review, because refugee status cannot be sought in removal proceedings. It can only be applied for outside the United States, and an immigration judge cannot grant refugee status, cannot consider an application for refugee status. 1252 does not apply in this case to a decision made by an agency completely and wholly outside of removal proceedings. And so I would ask this court to find that the district court erred, and in finding that this was a wholly discretionary decision, and we ask this panel to remand the case back to the district court for further proceedings under the APA. Thank you so much.
Counsel, we appreciate both of your arguments. You're excused and the case is submitted. All right, are we ready for the next case? Yes. Next case is 25-6000 Lancaster versus Cartmell, sorry. And Ms. Eads, Mr. Riffle first.
Yes, my name's Mr. Riffle, Craig Riffle. I represent the appellant, who's also the plaintiff in this case. That we're here because the court dismissed this case on a 12B6 motion. The plaintiff had filed his complaint alleging he was qualified for Medicaid benefits, that he couldn't be penalized under the loan that was in this case, and that he was entitled to injunctive relief. The defendants responded by filing a 12B6 motion, which the court granted. Now, on the dismissal standard, what I'd really like just to do is highlight the Brown case that the 10th Circuit decided in January of this year. And what that case says is it says that the district court, in reviewing a 12B6 motion, must restrict its review to the allegations within the four corners of the complaint, cannot consider other pleadings or external allegations. Now, there are three exceptions to that, one being an exhibit attached to the complaint, or two, a document referenced in the complaint, or three, anything the court can take judicial notice of. The Brown case is a very good case. It summarizes the long line of jurisprudence we have regarding the dismissal standard. I mean, it incorporates the Ashcroft case from the Supreme Court that says a plaintiff just must only plead sufficient allegations and must not prove those. It incorporates the Munt case, the 10th Circuit case from 2024, which says that the court must accept the well-pled allegations and construe them most favorable to the plaintiff. The Glover case, which says the plaintiff is not required to prove his case at this point. And so,
I'm sorry, go ahead.
Oh, the Skinner case, which says that the court's neither to assess legal feasibility or weigh the evidence. And so what the court did in this case is the court did exactly that. The court went beyond the four corners of the documents, considered information, allegations that were external to that, and even arguments that were external to the complaint.
After Medina, does any of that matter?
Yes, it does. Medina was a case that talks about whether a private right of action is created, and it does focus on spending statutes litigations. But what's really important about Medina is it doesn't overrule a private right of action in this case or in any particular case. What it does is it gives a lot of instruction to lower courts as to how to apply the Gonzaga standard. The Gonzaga test, Medina is real clear in its reading that it considers Gonzaga to be the gold standard. And it didn't even go as far as overruling Wilder or Blessings. But it says that the statute that we're following must satisfy the Gonzaga standard. Now, what's also important is that we already have a circuit court, I believe it's the Third Circuit in the case named Sabry, that went through excruciating detail and explaining about how this particular statute that we're relying on in this case does satisfy the Gonzaga standard. And that statute that we're relying on is specifically 1396 AA8. And it went through that, it applied the Gonzaga standard and walked through all the steps enumerated in Gonzaga to determine that, yes, it does create a private right of action. It's probably the best.
Medina casts a lot of skepticism towards the the other cases, Wright, Wilder, et cetera, in Medina. And those were the primary cases that Sabry relied on in reaching its conclusion. What do we do about Medina's fairly broad statements about the limited precedential value of those cases, even though it didn't outright reverse them?
Your Honor, Medina relied heavily on Gonzaga. It addressed Wilder, Wright, and Blessings. It didn't overrule those. I agree, it cast doubt as far as their application, and it really provided limits on their application. But Medina was very, very clear in stating that and illustrating where Gonzaga is the gold standard. Now, the Sabry case applied specifically Gonzaga to our statute and held that it does create a private right of action. Additionally, there's been 6 other Court of Appeals that have found that our statute also, under Gonzaga, does create a private right of action.
But those are all before Medina.
That's correct, but they're based upon the same authority. In other words, all those statutes, Medina is based upon the Gonzaga standard, Sabry's based upon the Gonzaga standard, and so are those other cases. Now, Sabry in particular is based upon, it goes into great detail about how Gonzaga satisfies that test.
And what would you say, why is this statutory provision clearly and unambiguously creating a private right of action?
Well, I think Sabry said it best in going through and comparing the actual language and enumerating the 3 parts, the 3 steps that have to be followed. And that's why the Sabry case was so very important, is because it provided an analysis as how to analyze 1396 AA8 under Gonzaga. And it enumerated the steps, talked about everything that Gonzaga talked about, and even compared 1396 AA8 to the statutes that Gonzaga held did create a private right of action. For instance, Gonzaga considered a couple statutes in which they prohibited discrimination, and they specifically said that the state shall not do whatever it was, shall not discriminate, and they were specific to this, or they referenced specific individuals. What Sabry did is went in and considered that as well and said, well, when we compare 1398 AA8, the language to those two, to the previous statutes in Gonzaga, the language is the same. It says the state, it says shall not, it says the state shall, but then specifically identifies a specific person to be benefited. Now that's very different than the statute that was considered in Medina. The Medina statute was much more general in its application. It talked about as far as the things that the state may do, and also talked about in terms of funding being withheld, or that the governmental body that was in charge of that would restrict funding if a certain policy wasn't followed. And so that's really how they are distinguished. And Savory was a real good, in my opinion, was a real good analysis of painfully walking through every step. I mean, it even went through and covered congressional preclusion. So in this case, what we have is the case was dismissed on a Rule 12b-6 motion. The problem with that is that the court went well beyond the four corners of the complaint. The court considered information and documents that weren't even in the complaint. That's why we're here. The court talked about Medicaid entitlement and the note being a resource, things that weren't in the complaint. The court basically tried this case in the motion to dismiss phase, and keeping in mind we haven't had any kind of procedure in this case yet. There's been no discovery or anything else. The court did not limit its inquiry as to the plausibility of the plaintiff's complaint. The court order is evidence of that. It has many different statements regarding arguments arguing against the plaintiff's position, instead of just assessing the plausibility of the order. The other thing, or of the complaint, the other thing that's problematic about the order is the fact that the Medicaid applicant had a loan in this case to an LLC, and the order contradicts itself. In other words, the judge specifically identified the proper regulation in determining that we have both formal and informal loans. The court also properly identified that same regulation says an informal loan is between individuals who are in the business, not in the business of lending money, and then concluded that the loan was not an informal loan. Well, then the court had to have concluded that the LLC was an individual in order to fit the definition. Now, the regulation doesn't define individual. Black's Law Dictionary would define that to include an LLC, but in the very next paragraph in the order, what the court did is the court went in to say although the court's already concluded the LLC is an individual, already concluded it was an informal loan, the court came in and said, no, the LLC is not an individual. The order itself contradicts itself is one of the problems. The last thing I'd like to say at this point, and before I reserve time, is that in the state's response, they pointed out that Mrs. Lancaster is deceased and she has died. There's a big difference in this case versus prior authority. There's two cases out there, Pekka, one's named Pekka and one's named Lamley. And in those cases, they were single person applicants. They were not married in any way. So what happened in those cases is when they died, their Medicaid eligibility was no longer alive. It was not a controversy because the only one that could benefit from that eligibility would be the applicants. This case is different because it's a married couple case. And not only is it a married couple case, but it's a married couple case in which both Mr. and Mrs. Lancaster sought benefits. Their application was filed in October of 23. Mrs. Lancaster died in October of 24. Mr. Lancaster is still alive. But the reason Mrs. Lancaster's eligibility is still important is because in this particular case, both the statute and the regulations say in determining his eligibility that we have to add, or we have to consider assets of both spouses in determining his eligibility, except if she's eligible, if she's already qualified for benefits. In other words, if she's determined to be Medicaid eligible, then that computation would not work that way. We would not have to pull those assets into the computation.
But the claim is for wrongfully being denied future benefits, right?
Yes, and I don't think
she's dead. She can't get any future benefits. So whether she's married or not, she has no claim. It's moot.
I agree with that as far as the payment of benefits. What I intend to say is that her eligibility is still an issue. In other words, her application is not moot because not for the payment of benefits, but for the determination as to which assets must be included or not included in Mr. Lancaster's application. If she was determined to be Medicaid eligible on that application, then the assets are counted differently than if she's not Medicaid eligible.
I mean, even if she's dead?
Yes, because it affects his calculation. Now, I agree, the appellant doesn't say that she's entitled to benefits. The appellant's saying is that her Medicaid status affects what assets are counted in Mr. Lancaster's application. And I've cited that in the brief. The statute
But it's her eligibility before she died.
Correct.
And once she died, her eligibility is irrelevant, even to him.
Correct.
Okay.
Correct. I'm sorry. Yeah, it's the eligibility that at the date he died, because it has a bearing on his application, not her eligibility today, obviously.
Well, does it matter that the application was filed before she died? In other words, could a husband whose spouse had died then realize that it would have helped him if his deceased spouse had been Medicaid eligible? Could you do it retroactively?
I don't know that you could do it retroactively. What does have a bearing on this case is because since he's alive, he's entitled to injunctive relief. Well, that injunctive relief will also give rise under 1396 AA 34 to the payment of benefits back to the date of application, not for her, but for Mr. Lancaster. Now that case, that statute's already been analyzed. The Marin's case, the Bernard case, they're in our brief. If I may, I'd like to reserve the rest of my time for rebuttal.
Okay. Thank you, Counsel. I think Miss Eads was going to go first. You may proceed. There you go.
May it please the court. I'm Susan Eads, and along with my co-counsel Josh Holloway, we represent the Appellee Director Jeffrey Cartmell of the Oklahoma Department of Human Services. We're joined today by Mr. Ryan Gillette, who represents the Appellee, the Oklahoma Healthcare Authority. In this matter, Mr. Gillette and I would like to split our time equally today. So I will be first addressing the aspect of the determination on benefits and eligibility for the Lancasters, and then Mr. Gillette will then discuss that the appellants are not entitled to the relief that they seek under 42 USC 1983 and 1988. Also, they're directing the court's attention to the Appellee's joint motion for summary disposition that was previously summarily denied by this court in favor of having the oral argument here today. I want to first off thank the court for giving us the opportunity to be able to bring the issues in this case back into focus. I want to begin with Mrs. Lancaster's claim. What was absent from the oral argument just presented by Appellant's counsel was the fact that this court should dismiss Mrs. Lancaster's claims because she lacks standing currently as she passed away in October of 2024. As pointed out by Appellant's counsel, there's been no substitution of a real party in interest on her behalf. Currently, she is proceeding in this case by and through her daughter, Jan Green, who held her power of attorney during her lifetime. But as the court is aware, the efficacy as well as the authority of that power of attorney died when Mrs. Lancaster died. So therefore, there is no standing for Mrs. Lancaster's claims to proceed herein. So appellees ask that Mrs. Lancaster's claims be dismissed as a result. Now, turning our attention to the claims of Mr. Lancaster, as was alluded to in Appellant's argument, the underlying issue here includes a determination by the district court that the Oklahoma Department of Human Services denial of eligibility for Mr. and Mrs. Lancaster was appropriate. There was the underlying transfer of substantial resources by Mr. and Mrs. Lancaster, totaling $3,754,228 in exchange for a $3.8 million promissory note. Now, it's notable, Your Honors, that at the time of application, the maximum resource threshold per individual was $2,000, or a total of $4,000 for the couple, Mr. and Mrs. The appellee Oklahoma Department of Human Services did deny the eligibility to Mr. and Mrs. Lancaster because the underlying promissory note was not a proper informal loan and it was not bona fide. And also there was the determination by the agency that the underlying transaction created what essentially is a trust-like device.
What do we do with the fact that in the decision itself, the court contradicts itself? It rules first, it concludes first that the promissory note was an informal loan because those involved were individuals not in the business of lending money. And then in the next breath, it says that the loan was not informal and accepted the government's argument that the loan had to be informal to be bona fide. Aren't those conflicting findings?
Your Honor, with regard to that issue, the district court noted that there was no legal authority put forward by appellants that the loan was anything other than an informal loan. There was no case law, there was no legal authority cited to make it a formal loan. And just because there was personal guarantees that were issued by the three children of the appellants did not then convert it to a formal loan.
Well, that may be true, but the court said it's an informal loan, and then it said it's not an informal loan. I mean, if nothing else, don't we need clarification on that?
Well,
does it matter to the determination of whether the promissory note was a countable resource, whether it is or is not a formal loan?
Your Honor, it's my opinion that the district court's order, it clearly and unambiguously determines and concludes that the loan is an informal loan, and it is an informal loan based upon the Social Security Administration's program operating manual, affectionately referred to as the PALMS. So they did make a clear finding of that, and that's a legal determination that was made. So the court agreed and concluded in agreement with the appellees that the loan was an informal loan, and it wasn't a proper informal loan because it was not between the individuals. It was between two individuals, Mr. and Mrs. Lancaster, and the family LLC.
Well, you can see why we're struggling a little bit, and it's the start of page 4 there where it says applying the same plain language. The court also agrees with the informal loan, so it's sticking to it, that its informal loan is not bona fide because it was not made between individuals, period. But if you look at 220D, what's cited, it's the same section that was cited earlier. Is it just the court not continuing the thought and including the rest of the words? Or is it something?
I would say that's correct. I mean, again, the issue here is, I mean, you can put lipstick on a pig, but it's still a pig ultimately. The reality of it is that the resource amount, the $3.8 million resource amount was determined by the agency and then determined by the court that it was a countable resource, and in other words, was available to Mr. and Mrs. Lancaster to pay for their own long-term care expenses. And that they were not doing $8 million.
It's not just that they gave $3.8 million, it has to be for reasons. And the reason the court gave was it's informal and it's not bona fide.
Correct. And the bona fide aspect also goes to the appellee's briefing on the aspect of the repayment term under the promissory note was not feasible, which is one of the clear factors to be considered as to whether a promissory note is bona fide or not bona fide. And in this case,
we're past the district court opinion in this discussion, aren't we? The district court just said not bona fide and cited that. It didn't get into feasibility, did it?
No, sir, it did not, because ultimately the district court earlier on page 3 of the opinion had indicated that, for a promissory note to not be considered a resource, it must be bona fide, cited to the Palms 1120.220C2C there. And so that's the situation where they made a finding that carries on and talks about the informal loan is a loan between individuals who are not in the business of lending money or providing credit. And if it is informal, it is bona fide if it's enforceable under state law, a loan agreement was in effect at the time of the transaction, there's an acknowledgement of obligation to pay, there's a plan for repayment, and the repayment plan is feasible. So it does, district court does touch on the aspect of that requirement that the repayment plan be feasible, but it determines that ultimately we're not going to look any further because we agree with the appellees herein that the loan itself was an informal loan, and it's clear and unambiguous language brought about by the Palms that it has to be between individuals. There's also the application there, Your Honor, of the case of Muhammad versus Palestinian Authority, 566 U.S. 449 at 453 to 456, which specifies therein the court held unanimously that the individual, as used in federal statutes, encompassed only natural persons, excluding organizations. So the district court felt very confidently that this case involved an informal loan that was not between individuals as was required. And so therefore, they determined that the underlying amended complaint should be dismissed because while there might be a cause of action, it wasn't properly pled as such.
Can I ask you just a point of curiosity, which is when the money comes back, the first payment, the $100,000 or whatever it was, wouldn't the recipient immediately be ineligible for too many resources, or how did that work?
No, Your Honor. Actually, the payment terms under this loan were for around $850,000 per year. And so ultimately it should work that when the individual receives the repayment of the $850,000, it could make them ineligible at that point because they're over resources at that point.
Yeah, I have my numbers.
However, what has happened in other cases that we have been involved with that Mr. Riffle has cited to, and some he has not cited to, is that Mr. Riffle's firm has taken the promissory note, transferred it to a trust that became irrevocable at the death of the beneficiary, and excused any liability for repayment by the borrowers. And so that's a problem that we have not seen in this particular case, but that can be an issue there. They also have been involved in previous cases that have went before the 10th Circuit where when that repayment is made, that annual payment is made, it is immediately swept up into a successive promissory note. So they
right. And I realized that this it's kind of an impoverishment system plan, and they're going to vary. Have you ever seen this one before? And are you aware of any cases where courts have dealt with something similar to what's being done here? In other words, is there any authority, or are we on our own?
As far as in what aspect, Your Honor, as far as with regard to the promissory note being between an individual and an LLC?
No, the money's here, the money's there, the money's not really there, it's really over here, and we're eligible.
Right. That would ultimately be looking back at the Rose case. It's the Brown case, and in the way that Mr. Riffle referred to it. That involved 3 different individuals who had promissory notes, and the aspect of how the Medicaid planning was used there concerning those promissory notes. We also had.
Yeah, I was going to. You're almost out of time, and I'd like to hear.
Thank you.
Yes, I'll just pass my time to Mr. Gillette at this point.
Thank you, Your Honors. May it please the court, Ryan Gillette for the Oklahoma Healthcare Authority. Counsel addressed her issues, and I'll do my points, two narrow points. First, Medina was decided during this appeal, and I do think when you follow that, it's in line with this court's prior precedents in Hobbs and Mandiar, and finds that the statutes at present here do not clearly and unambiguously create rights, individual rights enforceable under 1983. And in regards to the individual cases of Blessing, Wilder, and Wright, while I agree with counsel that the Supreme Court not overturn those, I think in Medina, Justice Gorsuch clearly cautions lower courts to no longer rely on those cases when dealing with spending clause statutes. The second point I'd make briefly is that even if the provisions invoked here are not privately enforceable under Section 1983, that does not leave Medicaid beneficiaries, including Mr. Lancaster in this situation, without meaningful avenues of relief. There is a robust structure for beneficiaries to seek relief outside of 1983 through administrative hearing process that's reviewable by the state courts and ultimately can seek certiorari from the United States Supreme Court. In fact, Mr. Lancaster filed such an administrative appeal and asked that the administrative court held it on abeyance while he sought this case at issue here. And finally, in conjunction with that, there's also federal oversight. HHS has the ability to accept complaints from beneficiaries, can issue corrective actions to the state, and even in extreme systemic issues, withdraw federal funding. And with that, Your Honor, we ask that this court affirm the lower court's decision, if not for the reasons cited by my co-counsel for DHS, for finding that there's no private right of action under 1983. Thank you.
All right. Thank you, counsel. We have some rebuttal time.
Yes, this whole discussion proves my point about the fact this was a 12b6 motion. Counsel has spent their entire time arguing the merits of the underlying case. That's not the proper standard under all the jurisprudence we have, both from the 10th Circuit and the Supreme Court. That may be proper for a motion for summary judgment, but it's not proper for a 12b6 motion. And the court went way beyond its authority and considered any arguments outside the complaint. This whole discussion illustrates that and these other allegations that have been made. The other thing I'd like to say on the formal versus informal, let me say specifically, as I said earlier, the regulation says, quote, an informal loan is between individuals who are not in the business of lending money. I'm reading from the court's decision that says, page 3, bottom paragraph, applying this plain language, which is referring to that, the court must conclude that the plaintiffs made an informal loan to the LLC. Well, then he had to conclude that the LLC was an individual. But on the very first sentence of the next paragraph, he says, applying the same language, the court also agrees that the informal loan is not bona fide because it is not made between individuals. That is directly inconsistent. In their sentences, they abut each other. The first sentence, he says they are an individual. The next sentence, he says they're not. The other thing I'd like to say is Medina didn't overrule Wright, Wilder, and Blessings. Counsel's correct. It gave instructions and caution courts, but it did not overrule those. The court could have. And the last thing I like to say is we're not seeking benefits for Miss Lancaster. We understand that Mr. Lancaster is asserting her eligibility in trying to determine his Medicaid eligibility in his application, which is required. Thank you, Your Honors.
And counsel, we appreciate the argument. Your excuse and the case is submitted. All right, we have one final case this morning, and it is 25-7009 Brown versus Flowers. Mr. Capron.
Thank you. May it please the court. I have a fundamental factual proposition that I want to start my argument with that I think is undeniable in this case, and that is that the policy that we're dealing with in this case absolutely provides coverage for some sexual misconduct claims. The reason I think that's important to start with is because both rationales that the trial court gave for denying coverage in this case presume that all sexual misconduct claims are not covered or that there is no coverage. In fact, that's also the underlying factual presumption of the argument made by the garnishee in this case. The fact of the matter is the policy is very clear that some sexual misconduct claims are absolutely covered, not just for a duty to defend, but a duty to indemnify. I'm referring specifically to the appendix, page 227, which is where you find the exclusion 38. Exclusion 38 separates both the duty to defend and the duty to indemnify, and specific as to sexual misconduct claims says that there is coverage for sexual misconduct claims. There's both a duty to defend, and after liability is found, there is a duty to indemnify. That's subparagraph 3 of exclusion 38. 38 says, ACOSIG will indemnify a plan member for liability arising in connection with a sexual misconduct claim unless two things are found. And I'm going to come back to those two things, but again, the fundamental first proposition I want to establish is that there is coverage for some sexual misconduct claims. And in this particular case, even coverage after a verdict or a judgment and verdict and judgment are entered and liability is found. If you look at the trial court's order, the trial court started with saying Mr. Flowers was not a plan member because he fell outside of the scope of his duties. And he said as a separate matter, if it was a plan member, this exclusion 38 applies to exclude coverage. In both scenarios, the trial court assumed that that the fact that this was what he called a sexual misconduct claim necessarily meant that Flowers was not insured. Specifically, if you look at page 5 of the order, the trial court is finding that Flowers was not a plan member because sexual misconduct claims cannot be covered under the policy. There wasn't a finding of any of the things that would trigger a scope of duties analysis. In fact, the trial court expressly recognized that there was no jury finding on any of those issues. It wasn't just that there was no jury finding. This court, in a prior appeal, found that that was appeal 23-7006. This court found that summary judgment was properly awarded on punitive damages because there can't be such misconduct that would constitute criminal, fraudulent, malicious, reckless conduct, all the things that would take him outside of the course and scope of his duties according to the policy language.
Well, he pled guilty to 2 counts of rape, right?
Neither of which requires force. That's correct.
Well, you don't have to have force under the policy.
In this particular case, this is the claim that's at issue is not a rape case. It's an excessive force claim. And that's the distinction that I'm trying to make. He absolutely did plead guilty to those 2 counts, and neither one of them, of course, was relevant to the determination of liability in this case, as the judge instructed the jury.
Well, the inmate cannot consent, right? So it's rape.
That's not the way the case was presented to the jury. It was presented to the jury in this case based on consent being a pure defense. That's why I think the trial judge instructed the jury in our case.
Well, you've got 2 cases. You're talking about the civil case versus the criminal case, right?
That's correct.
Okay. In the criminal case, he pled guilty to 2 counts of rape that require non-consensual sex.
I beg your pardon?
That he had to have non-consensual sex. And by statute, I don't believe
consent was an issue in that case.
By statute, under Oklahoma law, she could not consent. If it were consensual, how could he plead guilty to rape?
Because I believe the statutory elements make just the fact of intercourse liability. Because
she can't consent as a matter of law in Oklahoma.
In the criminal case, that may have been the matter, but in the civil case that we're here on, that is not the way it was presented to the jury. The judge presented this with consent being a pure defense.
You're not here on that civil case. You're here on a garnishment proceeding to collect under the insurance policy. And so
that's correct.
Both of those cases are relevant here.
I don't believe that the criminal
case.
I don't believe that the criminal case is relevant because it didn't change the risk profile in this case for the garnishee. There's nothing about the admission by Flowers or any conviction by guilty plea that changed any of the issues for the insurance company in this case. Their liability was the same with and without the finding in that case, and that's exactly what the trial court instructed the jury on in this case, that it didn't matter. So the garnishee—
There wasn't a jury in this case.
Beg your pardon?
Do you think there was a jury in this case that is before us?
The case before us that I'm referring to is the case in which Flowers was found guilty and now we're seeking to, or liable for a 14th Amendment violation, and now we're seeking coverage for that. I think that case is the same as the one that we're bringing this garnishment action within. So I'm addressing the garnishment action and the civil action as one, because the civil action only looks at the liability of the garnishee in the civil case. Going back to my point, the policy clearly provides that there are sexual misconduct claims where coverage exists. The trial judge found that because there's sexual misconduct, that necessarily takes Flowers outside of the scope of his duties. That cannot be the case. That's an untenable position under the policy, the plain language of the policy. The policy
the plain language that says, the scope of the duties that I'm looking at says it shall not include any dishonest, criminal, fraudulent, bad faith, reckless, wanton, or malicious act. Well, we know
right.
He committed a criminal act. He committed 2 criminal acts, right?
He pled guilty to them, yes, but the jury—
Well, you can't accept a guilty plea unless you do a colloquy that gives the court a factual basis to accept the plea. He pled guilty to 2 criminal acts of rape.
And that didn't change anything under the insurance policy. That's true, but it didn't change anything under the insurance policy. The judge
specifically— Scope of duties says it shall not include any criminal act.
That's not what the insurance company is asked to indemnify here for. They're asked to indemnify pursuant to the plain language of their policy for the civil liability in the civil case that was tried to a jury and liability found without regard to the criminal matter. The criminal matter stands, no matter how similar the parties are and the issues were, stands separate from this civil case, and that's exactly what the trial judge instructed the jury. The trial judge said that they are not finding guilt or innocence in that case, and that is not controlling of any issue in this case.
Well, that is true that it wasn't. It doesn't change the fact that with respect to the same set of factual circumstances, this man pled guilty to 2 counts of criminal rape, which are specifically excluded under this policy.
They are only excluded under this policy if Section 38 sub 3 applies, and it doesn't. It doesn't apply because Section 38 sub 3 specifically says that even in light of sexual misconduct—
Well, why don't you read it instead of paraphrasing?
ACOSIG will provide I'm sorry, that was sub 2. ACOSIG will indemnify a plan member for liability arising in connection with a sexual misconduct claim unless a final adjudication establishes or the plan member admits, goes on to the sexual abuse claim. And that's why I'm saying, yes, he pled guilty in that case, but no, it didn't affect this particular insurance policy or the application of this insurance policy to the civil matter. And it didn't because this policy clearly provides coverage to some people who are guilty of sexual misconduct claims.
It specifically says we'll cover an employer from an allegation of sexual harassment by an employee, right?
It says plan member, not employer. And that's what I was getting at.
Yeah, but that's an employee and says we cover that, but we don't cover this. And it's got, you're focusing on one, there's a bunch of hurdles for you. One is it in the scope of his duties? If it's in the scope of his duties, then you have to go to the exclusions. And you're focusing on one of those exclusions. What about the law enforcement exclusion?
I don't believe that's an exclusion that was found by the trial judge or that this
It
policy.
doesn't have to be found by the trial judge. It's a separate provision of the contract that says we don't cover this. It doesn't have, you're trying to import language from one provision into a different provision. It says nothing about that there in the law enforcement exclusion.
Well, respectfully, I'm not trying to import language. I was trying to start where you started with the plan member analysis. And the plan member analysis is you are not excluded from being a plan member because you engaged in sexual misconduct. If we assume that he did engage in sexual misconduct, and this is a sexual misconduct claim, the trial judge found that automatically removes him from plan member status. It doesn't. It cannot. That's an untenable position under a policy that goes on to say that plan members are still covered, provided that they don't make an admission of their guilt or have an adjudication of their guilt. And while I recognize that he did have a guilty plea in this case, I don't believe that that was something that changed the risk profile of the insurance company or the apportionment of the risk such that this policy then became ineffective. I think when this policy says that the admission or the guilty plea has to be found, it has to be something that affects the insurance company's interest. And it didn't in this case. It didn't in this case because
it's not the insurance company's interest. It's the application of the contract terms. You know, this is a contract.
That's right.
And
it's
they
a risk apportionment contract
to cover what they contracted to cover, and they didn't cover what they contracted not to cover. So
I agree with
their
that.
risk profile is irrelevant. It's
well, I don't, because it goes to the meaning of the contract. Beg your pardon?
What does the language on the page mean? That's what we're looking at.
The language on the page says that there are sexual misconduct claims that are covered. That's the plain language.
And that may be true, but they aren't covered if you're a law enforcement personnel and you rape an inmate.
They are if that is not subject to an admission or an adjudication. And the adjudication in this case is not the finding of liability in the civil matter. It has to be an adjudication of something else. And we know that because the plain language of 38 sub 3 says that there is going to, even if you're found guilty or liable for sexual misconduct, there's still going to be a duty to indemnify by the insurance company. It's plain language. And that language
so really
applies.
Under your interpretation of the insurance policy, any type of sexual conduct up to and including rape are covered by the policy, absent an admission, and a plea of guilty in a criminal case to rape is not an admission for purposes of the insurance contract.
That's exactly correct.
Okay.
And I'm saying that because the plain language says that even if you engage in what the policy defines as sexual misconduct, there's still coverage unless you have the admission of liability or the finding of guilt. And in this particular case, even though I believe it's undisputed that there was a plea bargain in the criminal case, I don't believe that was anything that changed the insurance company's acceptance of risk vis-a-vis the civil action in this case where Flowers was indemnified. And that's why I believe that there's coverage.
Okay, why doesn't the guilty plea count as an admission again?
Because as the trial court instructed the jury in this case, it was irrelevant to this case. It was not something that they can use as evidence in this case.
Relevant to the damage.
I'd like to reserve the remainder of my time if possible.
All right, let's hear from Mr. Rice.
Your Honors, thank you. Doug Rice on behalf and Pete Serrata on behalf of the Association of County Commissioners Self-Insurance Group, the garnishee and appellee in this case. So this case, as the court is aware, involves the determination of coverage of an insurance policy, which in this case is called a liability coverage agreement. We're not here to retry the underlying case. We're not here to retry Mr. Flowers' plea of guilt to rape. But the insurance coverage issue before the court is whether the sex between a jailer and a detainee, be it consensual or non-consensual, is covered by the terms and conditions of this particular insurance policy. We believe that the district court's finding that it was not covered is correct and it should be affirmed. So when we look at this case, there's just a few facts that I think resolve this issue, this coverage issue before the court. First, the conduct which is at issue before the court involves sex. This is a fact. There's no dispute between Ms. Brown or Mr. Flowers that this case involves sex. In Flowers' answer to the complaint in this case, which is at appendix page 20, he says that he admits only that he was charged with and pled guilty to second-degree rape for having consensual sexual intercourse with a detainee. And then in his affirmative defenses, found at page 22, he makes clear that his defense to Brown's allegations is that plaintiff, who is Brown, consented to the sexual encounter with defendant Flowers. So Mr. Flowers admits that that conduct of sex did in fact occur. And for her part, Mrs. Brown, in the pretrial conference order, when she reflected what she believed were the admitted or stipulated facts, and I'm not going to read them all, but she said, Flowers engaged in the challenged governmental actions of causing the removal of Ms. Brown's clothes and the raping of Ms. Brown, and that Flowers admitted his actions were intentional. I would also point out that in her brief to this court, to the 10th Circuit Court of Appeals, in case number 237006, which is a case where Brown appealed some certain findings by the district court, that in her statement of the case, she used the term rape or rapist no less than 37 times to describe the conduct at issue in her case. Further, the entire case at trial was whether the sex between her and Flowers, who's the jailer, was consensual or non-consensual. The court, in instruction number 11, instructed the jury that the jury was to find that if they found that the defendant coerced plaintiff to engage in sexual intercourse with him, that was sufficient to show an objective harm that violated plaintiff's 14th Amendment rights. And alternatively, if they found that plaintiff and defendant engaged in consensual sexual intercourse, you may not find that plaintiff's 14th Amendment rights were violated. That's at page 66. As the court is aware, the jury did find in favor of Brown and awarded her compensatory damages of $75,000. But regardless of how the plaintiff tries to characterize this now for purposes of coverage, the fact remains that the conduct, the underlying conduct that's at issue in this case, was entirely founded upon sex between Flowers, a jailer, and Brown, who was a detainee. There's no ambiguity or uncertainty in that fact. The second fact that is critical.
Can you tie this, all these facts that we already know, can you tie it to the language of the policy and tell me what your argument is? Are you saying it doesn't fall within the scope of his duties? Are you saying that it's excluded? What is your argument?
There are several arguments. And that second fact, of course, as you pointed out, Judge McHugh, is that he pled guilty to rape. He doesn't deny that. He admits that in the pleadings in this case, and that's not something that was ever disputed. So I think in terms of tying that to provisions in the policy, there's a couple of provisions that I think are important. First, someone like Flowers, an employee of Pontotoc County, who is, it's important to note, this is an insurance pool. This is an insurance pool where 73 counties or 74 counties in Oklahoma have gotten together to pool their liability. They are our both insureds and insurers. They write the policy terms. This is not your typical insurance company. This is an interlocal cooperation act where they've pooled those reserves. So I think that's important because Pontotoc County, who was Mr. Flowers' employer, participated and helped to write this policy. So this reflects the intent of all of our members, including Pontotoc County. When you're looking at getting to your question, Judge McHugh, the policy provisions, it does provide coverage for someone like Flowers, but only if they are performing and acting within the scope of their duties.
Okay, so your first argument is that it doesn't fall within the scope of his duties.
Correct. That's a defined term under the coverage agreement. And under the definitions of the coverage agreement, it requires an employee to be acting in good faith in the performance of their duties or tasks lawfully assigned to them. That
if he's committing a criminal act, it's not covered, right? It's not within the scope of his duties.
It's not within the scope of his duties. He wouldn't be a covered plan member. And that definition even goes on. If you look at that definition, it further makes it clear that not only do they have to be acting in good faith in the performance of their duties, but it then goes on to say scope of duties shall not include dishonest, criminal, fraudulent, bad faith, reckless, wanton, or malicious acts. Then it goes on to also say any act that results in a claim of alleged sexual abuse will under no circumstances be deemed to further the interest of a plan member. So not only do they have to be acting in good faith, but there are specific provisions that would take Mr. Flowers' conduct out of him being covered as a plan member.
Well, could you rebut Mr. Capron's interpretation that that he never made an admission that would be relevant for contract interpretation purposes?
Well, he has made that admission. He has made that admission in the pleadings on file in this case. He admits that he was charged with rape. He admits he engaged in sexual intercourse with Ms. Brown. Ms. Brown contended, that was the entire case. Ms. Brown contended that they engaged in sexual intercourse, but that it was non-consensual. The entire case was consent versus non-consent. That was the civil case. But when you're looking at
what about
coverage,
the criminal case? Does the criminal case have relevance to the scope of duties?
Absolutely, it does. We're not limited when we're looking at coverage. We're not limited to simply the precise issues that were addressed in the underlying case. We are able to look at all relevant information and factual information. There's no case that says that in looking and interpreting an insurance policy and coverage, you're limited to an underlying case. If that were the law, we would see insurance companies intervening in these types of cases all the time to protect their interest and litigating issues that had nothing to do with the underlying case.
Well,
so,
is there a definition of sexual misconduct claims in the policy?
There is a definition of sexual misconduct.
There's a
long list of things.
It's any sexual act that results in damage. It's considered sexual misconduct, right?
Correct.
And here, damages were awarded for this sexual misconduct, right?
Yes, as a result of the violation of Brown's 14th Amendment rights.
So that would be another reason it doesn't fall within the scope.
Correct. Sexual abuse and sexual misconduct is defined in the policy at definition 33. It is a very broad definition. It lists not only does it say that any type of attempted or alleged sexual act by any person or any persons which causes physical and many mental injuries to anyone will not be covered. But it lists sexual harassment by non-employees, sexual humiliation, sexual advances of any kind, rape, and any other sexual act or alleged sexual injury.
Okay, Mr. Kappa says you can interpret the policy that way because it does cover some sexual misconduct claims. How do you respond to that?
Sure, it would cover, and I think it even says that in the definition that it doesn't include sexual harassment claims. Sexual harassment claims, to the extent that may be some type of sexual abuse claim or sexual misconduct, could be covered in some instances. Obviously, just like this case, it's a fact-by-fact basis, but there could be that type of coverage. But what I think is clear is that when you're talking about the act of sex between a jailer and a detainee that results in statutory rape, that there's no real colorable argument that ACO-SIG and its member Pontotoc County ever intended for that to be considered within the scope of a jailer's duties and is going to be covered by their insurance pool. And that, in addition to those definitions, there are also, if you take it outside of the definitions of scope of duty, sexual abuse, there are exclusions in this case. So the exclusions, and I'll just touch on those briefly, that I think would be most applicable are going to be exclusion 34, that excludes any loss in which the named plan member, its employee, or its volunteer has acted outside the scope of duties or in a grossly negligent, willful, wanton, malicious, or reckless manner. And importantly, that applies to all liability coverages under that agreement. It's not limited to certain types of coverages. It applies to all of them. And then, of course, the sexual acts exclusion, exclusion number 38, which is a very broad exclusion that includes any claims or alleged losses and damages arising out of, related to, or derived from any sexual abuse if a final adjudication establishes or the plan member admits that the plan member participated in the sexual abuse. One, I think that makes it unmistakably clear that ACOSIG and its member, Pontotoc County, intended to exclude this type of conduct, but also that it intended to exclude not only something that had been finally adjudicated, like we have here with the plea of guilt for the statutory rape, but also if someone admits that they entered into that conduct. And here we have Flowers admitting that he had sex when he was a jailer and she was a detainee. He admitted that they had sex. So
his argument is he didn't admit that it was non-consensual, and therefore it doesn't fall under him admitting to sexual abuse. Can you deal with that?
Yeah, the policy, we're constrained to the written language in the policy, and that's how the court is to interpret this, that the way the policy is written in its express ordinary terms, the policy makes no distinction between consensual or non-consensual sex. If a jailer has sex, whether it's consensual or non-consensual, with a detainee, and that detainee asserts a claim, like happened here, then that is not going to be covered by this policy. Because,
and you're looking now at the law enforcement exclusion?
Well, I'm looking at the general exclusion number 38 that would apply. It doesn't matter. You don't see a requirement that says that they have to admit that it was non-consensual. Under the definition of sexual abuse, it's the conduct itself. It's the act itself. It's not whether or not there was consent. And of course, Judge McHugh, as you pointed out, there can't be consent in this type of situation. But neither the definition nor the exclusion make any reference to consent and say that we're going to cover consensual sex between a jailer and a detainee. It's the act itself. And that act itself is not in dispute in this case.
Well, before you run out of time, will you touch on the law enforcement exclusion? Because to me, that one is just completely plain that this isn't covered.
Yeah, it is, Your Honor. And, quite frankly, there's so many, when we look at this, we believe there are so many exclusions that would apply in here. But yes, the law enforcement exclusion found on page 38 of the policy also provides that we don't have any obligation to pay or even defend a claim brought about or contributed to by any criminal, dishonest, fraudulent, bad faith, reckless, malicious, wanton, or intentional act brought about or contributed to by any conduct in which the plan member deliberately violated or had knowledge of or consented to the violation of any federal, state, or local statute, ordinance, rule, or regulation.
Why don't you go ahead and wrap up?
Yes. For these reasons, Your Honor, ACOSIG and its member, Pontotoc County, never intended, agreed, or plans to cover any type of this type of sexual misconduct or abuse. We believe that the district court's order should be affirmed. Thank you.
Thank you, Mr. Kaplan. I think you had some rebuttal time.
Thank you, Your Honor. The the fact of this being a sexual abuse claim does not take it outside of the context of Flowers being a plan member. He was. Even though he committed sexual misconduct, he is still a plan member, contrary to what the court said. Plan members don't get excluded simply because they commit sexual misconduct, as proven by the fact of 38 sub 3 saying that some sexual conduct is covered. Sexual misconduct, I beg your pardon. This law enforcement exclusion only applies to one form of coverage. There are multiple other coverages that apply that exclusion has no bearing on, and we didn't even argue the law enforcement coverage. That exclusion does not exclude general matters in this case. ACOSIG did, in fact, recognize their duty after the plea bargain by defending Flowers throughout the case, and even after the verdict in this case, they continued to defend him, recognizing that they do have duties in this particular case. They are not dispelled or done away with simply because he engaged in sexual misconduct or entered a plea bargain.
All right, counsel, thank you. We appreciate your arguments. You're both excused and the case is submitted. The court will be in recess until 8:30 tomorrow morning. Thank you for your Zoom participation.
Thank you.
Court is in recess until 8:30 tomorrow morning.